two important things regarding your paper and one revision test paper one. The two important things regarding your paper was whenever you're attempting a paper, I told you have 6 questions. Okay, then 1 minute. If you're recording it now, I have to do something to make it proper one. Okay, no need. Wait, am I audible and visible?
Yes, sir.
Yes,
Just
sir.
let me mute myself and see if it goes. Now you can hear me, right?
Yes,
Because
sir.
usually when you
Yes, sir.
enable recording, the muting. I told you 2 or 3 important things in the revision first for all those who missed the first 2 revision classes. I told you the most important thing in a business law paper is to choose the right questions. Anyway, chapter 1, question 1 is compulsory, right? We already discussed the format of the paper. There are 6 questions of 2 marks each, of 20 marks each. You have to answer any 5. Out of which question 1 is compulsory. What out of which question 1 is compulsory? And all questions are divided into 3 sections: 1 ABC, 2 ABC, 3 ABC, up to 6 ABC. And ABC carries 776 or 767. So basically 7 plus 7 plus 6, 20 marks each. Now the important question is 1 ABC. What does 1A consist of? Generally Contract Act. What does 1B consist of? Generally Companies Act. What does 1C consist of? Either Sale of Goods Act or Partnership Act. What, either Sale of Goods Act or Partnership Act. Correct or no? So most of the revision test papers, mock test papers, you will see that format, that the first question which is compulsory will come from these 4 chapters. What will come from these 4 chapters? It doesn't mean that you have to leave out the other chapters, but generally it comes like this. Correct or no? Then from second, third, fourth, fifth, sixth, you have to answer any 4. And I told you that please be careful while selecting. So very quickly go through those questions and see where you're not comfortable. And there is no specific order, okay? So suppose you're very, when you read the question and you see question 6 is very interesting, where you know everything. Okay, attempt of question 6. Then you can come to question 2 or 3 or 4 or 5. But what you have to do is the questions which you know the best, attempt them first. So keep that in mind. Then from the remaining 2 or 3, you'll read the other questions. You'll decide which one has to be left out. So you have to be very careful. Second thing which I told you was that the paper is a mix of case studies and what? Theoretical questions. What theoretical questions? Now, for theoretical questions, what are the modes of discharge of a contract? What do you do? I told you have to have an opening body conclusion. What you have to have an opening body? So you'll mention, define what is discharge of contract, then give the various modes, underline each of those points, and then give these are the ways in which give a conclusion. I told you for all theoretical questions, they test you on 3 basic aspects: content, language, and organization. What content, language, and so your content, suppose the question is of 7 marks, content will be around 5 marks. 1 mark will be for the language, whether you're using legal language. Language doesn't mean whether you're using proper English or not. It means whether you're using the terminology. For example, I can say an offer. When one person tells another person, I want to marry you, that is an offer. That doesn't carry the legal language. When a person makes a proposal or when you use section 2H, consideration, when somebody gives something to somebody, it is consideration. That is not legal language. Correct or no? So you'll have to use legal language. And last one is organization. You should have an opening body conclusion, which I told you. Correct or no? So first, be very careful of the questions which you choose. And as I told you, there'll be a mix of practical and it. If you find in a question there are 2 theory and 1 case, usually in most cases there'll be 2 cases and 1 theory, or there'll be 2 cases and 1 theory.
Theory.
But if there are 2 theories and you're comfortable doing theory, do that question. Then keep doing those questions which you're comfortable with and leave out the one which you are not comfortable. Now, the question which arises mostly is when we are attempting the practical, these theory questions, you do that, that I've already told you. But when you're attempting a case study, what do we do? I told you you'll go with the facts of the case, 2 lines about the case, provisions and analysis, where you'll talk about the provisions of the case and the conclusion. For every case study, give a definition. So learn all the definitions properly, whether it's a definition of an agency, whether it's a definition of anything, right? So that becomes very, very important, because if you don't know the sections, don't bluff. Correct or no? I've already told you. This was what I discussed in the what? In the first revision, where there were only 42 people. So for the benefit of the remaining 35, I explained that. In the second revision, there were less, 38 or 40, where I discussed two important psychological techniques to deal with your exam. One, I told you something called as PMR, positive mental rehearsal, which I told you is followed by most athletes across the globe. From now itself, your exam is on 13th. Start imagining yourself going to the exam hall. Start imagining that the paper is according to what you want. Start imagining that the paper is easy. Start imagining that you're coming out of the exam very happy. And keep this positive mental rehearsal just before you sleep and just before you, after you have got up. So when this positive mental rehearsal goes on and you're feeling confident that you're doing well in the paper, during the exam time, you won't panic much. What you won't panic
Much.
much, because you're creating neural pathways in your head of positivity. Second thing which I told you was grading your anxiety. What it is called, grading your. So even after that, if you go to the exam and you start feeling nervous, close your eyes for a minute and observe your stomach is churning or your heart is beating fast. Observe it like a thermometer. From 100, it's coming to 99, 98, 70, or it's coming from 10 to 9 to 8. Look at that. And you'll find by the time it reaches 7 or 6, you'll be much, much more calmer. Don't write anything in a flow of emotion, because whatever you write will be all rubbish. Correct or no? Third thing which I told you, time your paper. I told you that there are 180 minutes in which you have to attempt 5 questions. So keep 35 minutes per question. So you'll have finish it in 175 minutes. Don't attempt the first 3 questions. You have already taken 2 hours or 2 hours 15 minutes, and the last 2 questions is you have to do it in 45 minutes. Then your handwriting becomes like cockroach, all that. So be very, very conscious about the time. What Be very, very conscious about the time. And I already told you, start writing now itself, so that you don't develop writing cramps. At least write 1 or 2 pages every day in some way or the other. And I also told you how to study. I told you state bound recall. However similar your emotional state is while preparing for your exams, take a quiet room, study there. If it is similar to the state in the exam hall, if it's quiet, if you're listening to music and studying now, in the exam, nobody is going to play music. If you're going to put your leg up on a table and study now, in the exam, nobody is going to give you a table to put your leg up. So I told you the emotional and physical state at the time of preparing for your exam should be the same emotional and physical state while writing your
Exam.
exam. Because if you don't do that, you're in trouble. What you don't do that, you're in trouble. So I told you have to be a little careful. What you have to be a little careful, because that is, I told you that I gave you the scientific reason for that: acquisition, consolidation, retrieval. And I told you in all these 3 stages, I told you why sometimes you write the exam, then the next day morning you have bath, you remember the answer, because you were in a relaxed state while studying. You're a relaxed state while taking the bath. So the retrieval becomes much easier. You're in a relaxed state while studying, but in the exam time you get panicky. The emotional state is not the same. So you will not remember whatever you have to study. Okay. Say a few words of prayer before you write your exam. You don't know. You might need some invisible support here and there, and start writing your exam. Even if you believe in God, or if you don't believe in God, if you have some belief in some energy, some universe, you just pray whatever you want. You can believe in anybody. You can believe in your parents. You can believe in anything. And just utter a small prayer and start your exam. Generally, you'll do well. What you'll do? Well. Now coming to the part. I finished one RTP of September 2024. I finished one MTP, one of MTP one. There were 3 MTPs. Now the question arises: there is one RTP of June 2024. They didn't send 2 RTPs, no, for to September 2024.
No, sir.
Now June 2024, I see a lot of students from the previous batch. If you want, I'll do that RTP, or if you feel I'm repeating that, then I will do the MTP too. So you all decide what you want. Should I do the RTP of June 2024? Many of you all I see are from the previous batch. Do you want me to repeat it? Is it okay? Have you all gone through this? You all didn't attend the revision section, so Or if you want, I'll do the MTP. What is your suggestion? If you want, I'll do RTP. RTP will go chapter wise. MTP will be very random. What will be very
Random.
random. So I will take three opinions and then we'll go by majority. Take any three people. Or if you want, whoever wants RTP, raise their hands. Whoever wants MTP, or you want me to take a poll, or I'll just decide myself, or Ambika will decide.
The polling.
We'll go with polling. How many people want RTP? Raise your hands. June 2024.
2.
How many have put up their hands?
4, sir.
In total, only 4. Okay, now 5.
Who's saying in
Six.
total only 4, now 5?
Bhavana.
Huh? Bhavana, this is Kaun Banega Crorepati audience poll. Bhavana, only 6,
No
huh?
majority, sir. Only 5 members.
Huh?
Only 5 members have raised their hand. No
For,
majority.
for RTP. MTP, the remaining, I am assuming you'll want to do the mock test paper, right? So I'm
Yes,
going.
sir.
So I'll go to
Yes,
MTP2. Now take out MTP2.
Sir, your video is off.
Is it? Is it on now?
No, sir.
What
No,
the
sir.
heck? Wait, let's see why.
Sir, your video is not connected.
Ayo, Rama. Oh, no, it can't be. Ah. You start it. I'll ask my son to come. He's here, luckily, in the house. On it, just hold on. I'll just mute it for a minute. Till then, you remove MTP2. Huh?
Yes, sir.
Okay. There's some problem with the camera, it seems. I'm so sorry. My son tried to fix it, but the camera itself is not getting added. So you all can manage me like this?
Yes, sir.
Hmm, hmm. Oh,
Mock test paper, foundation course, paper 2, business law. Question 1 is compulsory. Answer any 4 questions from the remaining 5 questions.
hmm.
First one, A. Under that first one, Ashok goes to supermarket to buy a air conditioner. He selects a branded air conditioner having a price tag of rupee 40,000. After a discount of rupees 3,000, Ashok reaches at cash counter for making the payment, but cashier says, "Sorry, sir, the discount was up to yesterday. There is no discount from today. Hence, you have to pay rupees 43,000." Ashok got angry and insists for rupees 40,000. State with reasons whether under Indian Contract Act 1872, Ashok can enforce the cashier to sell at discounted price, that is rupees 40,000. 4 marks.
Okay, now, so now understand this is 4 marks. Out of the first question, 7 marks. This is for 4 marks. Now, remember I told you there was something called as an offer, an invitation to offer.
Yes,
Remember we did. So first you give the definition and offer. When one person signifies his willingness to do something or abstain from doing something with a view to obtaining the assent of another person, it is called an offer. You'll mention the facts of the case. Anshu wanted to buy an air conditioner. He went to the cashier. The cashier refuses to sell him at a discount. Provision and facts. You'll give definition of offer. You'll also give the meaning of invitation to offer. An invitation to offer is where a person invites another person to make an offer, like through an auction, through a display in a supermarket, through an advertisement in the paper. Correct or no? So whenever goods are displayed, it is always an invitation to offer. It is never an offer. So when that Anshu is going over there, he's making an offer to the cashier, and this is similar to the case. What's the case? Boots Boots Chemists versus Pharmaceutical Society of Great Britain. Remember similar case? That itching oil I'd done with you all, remember?
Yes,
Yes, sir.
sir.
Yeah. So this is similar to that case. So here Anshu cannot insist on the discount because he's making the offer and the cashier is rejecting his offer and he's not making the acceptance. So conclusion, Mr. Anshu cannot get the air conditioner at a discount because the offer has been rejected. What the offer has been?
Rejected.
If you want, you read one or two lines up and down and go ahead.
Answer: an invitation to offer is different from offer. Quotations, menu cards, price tags, advertisements in newspaper for sale are not offer. These are merely invitations to public to make an offer. An invitation to offer is an act precedent to making an offer. Acceptance of an invitation to an offer does not result in the contract, and only an offer emerges in the process of negotiation. In the instant case, Ashok reaches to supermarket and selects a air conditioner with a discount price tag rupees 40,000, but cashier denied to sell at discounted price by saying that discount is closed from today and request to make full payment, but Ashok insists purchases at discount price. On the basis of the above provisions and facts, the price tag with air conditioner was not offered. It is merely an invitation to offer. Hence, it is the Ashok who is making the offer, not the supermarket. Cashier has right to reject the Ashok's offer. Therefore, Ashok cannot enforce cashiers to sell at discounted price.
Very good. Second question. B.
Second one,
A1, A2.
A2. Rahul, a transporter, was entrusted with the duty of transporting tomatoes from a rural farm to a city by Ashwin. Due to heavy rains, Rahul was stranded for more than 2 days. Rahul sold the tomatoes below the market rate in the nearby market where he was stranded, fearing that the tomatoes may perish. Can Ashwin recover the loss from Rahul on the ground that Rahul had acted beyond his authority? 3 marks.
No, this is again, you'll have to mention the meaning of agency. Now, this is a transport operator as an agent of the principal over here is Ashwin and the agent over here is Rahul. I told you duties and liabilities of an agent, and I also told you emergency duties of an agent. So, under emergency circumstances, the agent must do everything to prevent the loss of the principal or to prevent the loss of the shit. I
Principal.
forgot that name of that case. Hey, what was the name of that case? Yeah, that some railway company versus Hooland or something. No, what was it? Same case, right? So there it was butter. Here it is tomatoes. What it is? Tomatoes. So here
Tomatoes.
the agent has every right to sell it below the market price to prevent any loss to the principal. So here the principal agent cannot ask the loss from the agent. Anybody remembers that case? What was that butter case? Chi, 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 chi. When I did principle of agency and all, right? It was there in your textbook also? No, huh? It was there in your textbook. Okay, anyway, you read the answer for this. So here the agent has every right to sell it. See, because it's an emergency situation. This is the chapter on agency. Remember last chapter of your Indian Contract Act, right?
Yes, sir.
Anybody's written that case? Remembers it? Don't? Okay, doesn't matter.
Sir, Simpson Co. versus Midland Railway.
Yes, who's that clever girl?
Hiranmay, sir.
See, Hiranmay is the true Simpson Co. versus Midland Rail Company. Same thing. Simpson had given that butter to be transported. That Midland Rail got stranded. So the engine driver sold that butter at a lower price to the villagers. But Simpson filed a case for this thing. So here it is tomatoes. What here it is? You had written it down or what had you done? Hiranmay?
I had written it, sir.
Very good. You're a smart girl. Okay. Simpson Co. was a Midland Rail Company. Now, Ambika, I'll read the answer.
Answer: Agent's authority in an emergency, Section 189 of the Indian Contract Act 1872. An agent has authority in an emergency to do all such acts for the purpose of protecting his principal from loss as would be done by a person or ordinary prudence in his own case under similar circumstances. In the instant case, Rahul, the agent, was handling perishable goods like tomatoes and can decide the time, date, and place of sale, not necessarily as per instruction of the Ashwin. Thus, the principal, with the intention of protecting Ashwin from losses, here Rahul acts in an emergency as a man of ordinary prudence. So Ashwin will not succeed against him for recovering the loss.
Very good. Go to the next question. 1B.
B1.
B1.
Mr. Mohan had purchased some goods from Sunflower Limited on credit. A credit period of 1 month was allowed to Mr. Mohan. Before the due date, Mr. Mohan went to the company and wanted to repay the amount due from him. He found only Mr. Ramesh there, who was the factory supervisor of the company. Mr. Ramesh told Mr. Mohan that the accountant and the cashier are on leave. He is in charge of receiving money and he may pay the amount to him. Mr. Ramesh issued a money receipt under his signature. After 2 months, Sunflower Limited issued a notice to Mr. Mohan for non-payment of the dues within the stipulated period. Mr. Mohan informed the company that he had already cleared the dues and is no more responsible for the same. He also contended that Mr. Ramesh is an employee of the company whom he made the payment, and being an outsider, he trusted the words of Mr. Ramesh as duty distribution is a job of the internal management of the company. Analyze the situation and decide whether Mr. Mohan is free from his liability.
See, on the face of it, it looks okay only. Factory supervisor. So this is doctrine of indoor management. Remember the Turkwan rule? Correct?
Yes.
No? The outsider can dealing with the country, assuming that all the internal affairs are going on properly. Since he's the factory supervisor, he seems to be a person of responsibility. Suppose it was some factory clerk or something, then there is exceptions to the rule, no? Remember, we had done exception to the rule?
Yes, sir.
That Anand Bihari Lal versus Dinshaw company, where they gave that he purchased a property and he gave the money to that and that accountant transferred. But here, factory supervisor is normal person, so it's not an exception. So under the doctrine of indoor management, what he's done is right. He doesn't know who has the authority to collect cash or not. Correct, Anu? Got it? I feel that way, but even otherwise, there can be an exception also. Just read.
Answer: Doctrine of indoor management. The doctrine of indoor management is the exception to the doctrine of constructive notice. The doctrine of constructive notice does not mean that outsiders are deemed to have notice of the internal affairs of the company. For instance, if an act authorized by the articles or memorandum, an outsider is entitled to assume that all the detailed formalities for doing that act have been observed. The doctrine of indoor management is important to persons dealing with a company through its director or other persons. They are entitled to assume that the acts of the directors or other officers of the company are validly performed if they are within the scope of their apparent authority. So long as an act is valid under the articles, if done in a particular manner, an outsider dealing with the company is entitled to assume that it has been done in the manner required. In the given question, Mr. Mohan has made payment to Mr. Ramesh and he, Mr. Ramesh, gave two receipts of the same to Mr. Mohan. Thus, it will be rightful on part of Mr. Mohan to assume that Mr. Ramesh was also authorized to receive money on behalf of the company. Hence, Mr. Mohan will be free from liability for payment of goods purchased from Sunflower Limited as he has paid amount due to an employee of the company.
But if he acts foolishly, then it's not done. Remember that exceptions to the rule of window management? Remember we did that Anand Bihari Lal versus Dinshaw, correct? Did you all remember that forgery, 3 or 4 exceptions are there, right or no? Where this fellow sold some property and he went and gave the money to the accountant who said, I have the right to transfer the property, correct? So you say if the factory supervisor looked in, it was suspicious in nature, remember? In that case,
Yes.
it is, then it will be an exception. He will not get protection, but otherwise he'll get protection. What otherwise he'll get? You can mention that also. What you can get? Mention.
Protection.
Understand? Okay, go to the next one.
Second one, Mike Limited is incorporated in India having LIAISON,
Liaison.
liaison office at Singapore. Explain in detail meaning of foreign company and analysis on whether Mike Limited would be called as foreign company as it established a liaison office at Singapore as per the provisions of the Companies Act 2013, 3 marks.
So very easy. You have to first, they've asked what is a foreign company. So define a foreign company. After you define a foreign company, foreign company is 242, right?
Yes, sir.
So you come from India, 2 fro and 2 back. You go to India, you go to Germany, come back. That's why I said it's easy way to remember, right? So you'll mention foreign company, any company which is not incorporated in India but has a branch or carrying on business in India, either on its own or through a franchise, is called as a foreign company. Here, anyway, the company is incorporated in India. Any incorporated in India is an Indian company. It's not a foreign company. Whether or not it creates a liaison. Liaison is public relation office to carry out some details with outsiders, dealing with outsiders, might be supplying some goods to foreign companies, correct? Huh? So it is a Indian company. What it is an Indian company, it's not a foreign company.
Answer, foreign company, section 2, clause 42 of the Companies Act 2013. It means any company or body corporate incorporated outside India, which, first one, has a place of business in India, whether by itself or through an agent, physically or through electronic mode. And second one, conducts any business activity in India in any other manner. Since Mike Limited is a company incorporated in India, hence it cannot be called as a foreign company. Even though liaison office was officially established at Singapore, it would not be called as a foreign company as per the provisions of the Companies Act 2013.
It's incorporated in India and also it's not a foreign company. They mentioned, no, Mike Limited is incorporated in India.
Yes, sir.
Next one.
C. Whether a minor may be admitted in the business of a partnership
And
firm.
this you do partnership, right? And B.
2A, first one.
Okay, C, only one question, huh?
Yes, sir. Also explain the right of minor. It's a 6-mark question.
Okay, so that is partnership firm. So I told you, either it will be partner. Usually it's these three only: Companies Act, Contract Act, and Partnership, or Companies Act, Contract Act, Sale of Goods Act. Okay, let's go to 2A.
2A, first one. An auction of sale of the certain goods was held on 7th March 2024. By the fall of hammer in favor of the highest bidder X, the payment of auction price was made on 8th March 2024, followed by the delivery of goods on 10th March 2024. Based upon on the provisions of the Sale of Goods Act 1930, decide when the auction sale is complete. 3 marks.
So remember, in an auction sale, when the auctioneer does any act purporting the complete of a sale of an auction, that is the time when the sale is complete. So in this case, when he bangs the hammer, the sale is complete, correct? And now let's say they say he dropped the hammer, correct or no? And what was that eighth? What have they mentioned?
The payment of auction price was made
Suppose
on
they
8th.
say, instead of that, they say on 8th, the seller becomes insolvent, or the seller becomes
Insolvent.
and the official receiver of the seller is refusing to give the goods to the buyer. Can the buyer get back his goods, get the goods? The auction sale was on 7th by the fall of the hammer. On 8th, the seller Ambika became insolvent. Bhavna, the buyer, wants to take the goods, but the official receiver of Ambika is refusing to give the goods, saying that the goods had not been delivered. What will be since the sale is complete on the fall of the hammer, the buyer can claim the goods, or the buyer can claim the understood or no? Got it?
Yes, sir.
Hmm.
Answer. According to Section 64 of the Sale of Goods Act 1930, the sale is complete when the auctioneer announces its completion by the fall of hammer or in any other customary manner. In the given question, the auction sale is completed on 7th March 2024.
Next one.
Second one, certain goods were sold by sample by J to K.
K.
Yes. Who in turn sold the same goods by sample to L,
L.
and L by sample sold the same goods to M. M found that the goods were not according to the sample and rejected the goods and gave a notice to L. L sued K and K sued J. Can M reject the goods? Also advise K and L as per the provisions of the Sale of Goods Act 1930 4 marks.
So I told you, whenever a sale is complete, when the person does something inconsistent with the ownership, the property and the goods gets transferred from the seller to the buyer. J sold it on sample to K. So it's on approval or return basis. But K instead sold it to L. L sold it to M. So K has accepted the goods from J when he sells it by sample to L. L has sold it to M, so L has accepted from K. Now M has every right to return the goods because he's not accepted it. He's saying the goods are defective. But L cannot reject the sale. He can only claim damages. What he can only claim? Damages. Because by selling by sample to M, he has indirectly accepted the contract. What is indirectly accepted the contract. So our friend L will have to claim damages from K. K will have to claim damages from J. But M first part. So answer the question in parts. I've already told you. Read the first part. Say M has every right to reject the goods. Then you can say the recourse available to K and L is they can claim it from J. They can claim it from. I think so. We did this question, no? The RTP or something.
Yes, sir.
Yeah. Then just read it quickly.
Answer. As per the provisions of subsection 2 of section 17 of the Sale of Goods Act 1930, in a contract of sale by sample, there is an implied condition that A, the bulk shall correspond with the sample in quality. B, the buyer shall have a reasonable opportunity of comparing the bulk with the sample. In this case, M received the goods by sample from L, but since the goods were not according to the sample, M can reject the goods and can sue L. With regard to K and L, L can recover damages from K and K can recover damages from J, but for both K and L, it will not be treated as a breach of implied condition as to sample, as they have accepted and sold the goods according to section 13 clause 2.
Yeah, they've sold it to somebody else. I told you on sale on approval or return basis, only L would have borne the loss. Remember we did that case last time? Suppose J sells it to K on approval or return basis, K to L, L to M, and the goods are destroyed in M's custody before the approval is made, then L will bear the loss because we discussed that. No? When J is sold to K, K has the property and the goods gets transferred to K, K sold to L, L has accepted the goods when he sells it. Okay, we've done that. Leave it. Just go to the next one.
B. Mr. Rajiv, an assessee, was a wealthy man earning huge income by way of dividend and interest. He formed 3 private companies and agreed with each to hold a block of investment as an agent for them. The dividend and interest income received by the companies was handed back to Mr. Rajiv as a pretended loan. This way, Mr. Rajiv divided his income into 3 parts in a bid to reduce his tax liability. Decide for what purpose the 3 companies was established, Whether the legal personality of all the three companies may be disregarded. 7 marks.
This is that piercing the corporate veil. Remember, X on under what circumstances can you pierce? So first you have to explain under Solomon versus Solomon. There's a corporate veil between the company. The company is separate and the
Members are separate.
members are separate. However, in certain cases, the court will disregard the corporate veil. Among that, one is defrauding the government of tax and revenue, or defrauding the government of tax and revenue. This case is similar to the case of Dinshaw Monikji versus Petit. Remember petitioners? Correct?
Yes.
Where this man had divided his income among 3 or 4 companies and then he got it back as loans. The court had in that case decided that the 3 separate entities were the same as the assessee and the companies were merely created to avoid tax. What to avoid? Tax. So in
Tax.
this case, the identity of the 3 companies will be disregarded. What it will be? Disregarded, and the corporate veil will be pierced. What the corporate veil will be?
Pierced.
I did 3 cases with you, remember in that? Dinshaw Monikji versus petitioners. Then I did one more. What was that? Jugilal
Versus
Kamlapat versus
Commissioner
Commissioner
of
of Income
Income
Tax. And I did one more, the one very horrible case that was. Some case of that versus that Inland Revenue Commission or something. Okay, anyway. Remember the director's expenses? They showed it on the debit side, right? Whatever
Yes.
it was. Okay.
Answer: the House of Lords in Solomon versus Solomon and Co. Limited laid down that a company is a person distinct and separate from its members and therefore has an independent separate legal existence from its members who have constituted the company. But under certain circumstances, the separate entity of the company may be ignored by the courts. When that happens, the courts ignore the corporate entity of the company and look behind the corporate facade and hold the persons in control of the management of its affairs liable for the acts of the company. Where a company is incorporated and formed by certain persons only for the purpose of evading taxes, the courts have decision and disregard the corporate entity and tax the income in the hands of the appropriate assessee.
Okay, leave that. We will just skip it. We are getting late, I think. So, okay. Next one. You all understood this, right?
C.
Yes, sir.
LLP is an alternative corporate business form that gives the benefits of limited liability of a company and flexibility of partnership. Explain. 6 marks.
Always LLP will come in the whole paper for 6 marks. So study this chapter properly. And even that first chapter, which Ramay also did, that Indian judicial system,
Yes.
that will also come for 6 or 7 marks. So 12 marks, from those 2 chapters. Remaining 108 marks out of 120 marks are from other. So LLP is always only 6 marks. Indian judicial system is also only 1 question, 6 marks. Correct or no? So if you're, and these are always only theory questions. They won't give you a case. So if you're comfortable, attempt these 2 questions. Correct or no?
Yes.
Okay. Next.
3A. State giving reasons whether the following are partnership as per the provisions under the Partnership Indian Partnership Act 1932.
No, this is not there for me. This is Mehul Saldu.
B. The state government of X, a state in the country, is holding 48 lakh shares of Y Limited. The paid up share capital of Y Limited is 9.5 crores, 95 lakh shares of rupee 10 each. Y Limited directly holds 2,50,600 shares of Z Private Limited, which is having share capital of rupee 5 crore in the form of 5 lakh shares of rupee 100 each. Z Private Limited claimed the status of a subsidiary company of Y Limited as well as government company. Advise as a legal advisor whether Z Private Limited is a subsidiary company of Y Limited as well as government company under the provisions of the Companies Act 2013. 7 marks.
So first you'll have to give the definition of holding company and subsidiary company. 2 subsection 87, no? Subsection subsidiary company.
Yes,
When
sir.
the holding company has the control of the composition of board of directors, or it holds more than half of the total voting power of another company, it is called as a subsidiary company. Now tell me, how many shares is Y holding in Z?
2,50,600.
Huh?
2,50,600.
Out of 5 lakhs. Huh? How many Z? What is the share capital of Z, heroine?
Y Limited directly holds 2,50,600 shares of Z Private Limited, which is having share capital of rupee 5 crore in the form of 5 lakh shares of
5
rupee
lakhs. So
100
do
each.
2,50,600 divided by 5 lakhs is how much percent? Huh?
50.12.
So it is. So since it holds more than 50% of the shares, Z is a subsidiary company. What Z is a subsidiary?
Company.
Now we have to see whether Z is a government company or not. Now tell how many shares is X holding in Y. So first we'll have to define a government company. Government company is 245, right?
Yes, sir.
Yeah, where more than 51% of the share capital is held either with the central government or both the central government and state government. Okay. Now what is the, how much is X Limited a government company holding in Y? X, read that thing again. X.
A state in the country is holding 48 lakh shares of Y Limited. The paid up capital of Y Limited is 9.5 crores, 95 lakh shares of rupee 10 each.
Just to 48 lakhs divided by 95 lakhs. How much has come? How much percentage?
50.5.
50?
0.5.
Just missed. So since Y Limited, the state does not own more than 51%. Remember, for a government to own, you have to have 51%. So here, since it doesn't own 51%, Y is not a government company. And since Z is a subsidiary of not, only a subsidiary of a government company can become a government company. So Z Limited is also not a government. Now let's say they change the thing that the state government holds 49 lakh shares. How much is 49 divided by 95? Quickly.
51.58.
In that case, what would have happened? Y would have become a government company because more than 51% of the share capital is held by the state government. And the subsidiary of a government company is also a government company. So in the subsidiary of a company, you don't have to hold 51%. Even if you hold 50.01% also, you'll be considered as a government company. Then Z would have automatically become a government company. But since here Y itself is not a government company, so Z will also not be a government company. Understood?
Yes, sir.
Yeah, you can read out the.
Answer. According to Section 2 Clause 45 of the Companies Act 2013, government companies means any company in which not less than 51% of the paid up share capital is held by, first one, the central government, or second one, by any state government or governments, or third one, partly by the central government and partly by one or more state governments. And the section includes a company which is a subsidiary company of such a government company. As per Section 2, Clause 87 of the Companies Act 2013, subsidiary company in relation to any other company, that is to say the holding company, means a company in which the holding company, first one, controls the composition of the board of directors, or second one, exercise or control more than one half of the total voting power, either at its own or together with one or more of its subsidiary companies. In the instant case, the state government of X, a state in the country, is holding 48 lakh shares in Y Limited, which is below 51% of the paid up share capital of Y Limited. That is 48.45 lakh shares, 51% of 95 lakh shares. Hence, Y Limited is not a government company. Further, Y Limited directly holds 2,50,600 shares in Z Private Limited, which is more than one half of the total shares of Z Limited, that is 2,50,000 shares. Thus, the company controls more than one half of the total voting power of Z Limited. Hence, Z Private Limited is a subsidiary of Y Limited. Therefore, we can conclude that Z Private Limited is a subsidiary of Y Limited, but not a government company, since Y Limited is not a government company.
Okay, done. Next.
Fourth one, A, another first one. Mr. Gaurav and Mr. Vikas entered into a contract on 1st July 2024. No, sir, before that, one question. An anticipatory breach of contract is a breach of contract occurring before the time fixed for performance has arrived. Also discuss the effect of anticipatory breach of contract under the Indian Contract Act 1872.
So we've done that, no? When before the due date, a person refuses to perform the contract, it's anticipatory. Then we told what are the losses you can incur. Either you can repudiate the contract and claim ordinary damages, or you can wait till the due date. But if you wait till the due date, you stand the risk that in case the contract becomes void in between the anticipatory breach and the due date, then the contract will become null and void. I'm not doing this. We are skipping this. You read this on your own. This is a theoretical question. Yes or no? Got it?
Yes, sir. Yes, sir.
Hmm.
Fourth, A, under that first one.
Then what was that one? What was that? That was
that was third C.
3C. 3C. Okay.
4A, another first one. Mr. Gaurav and Mr. Vikas entered into a contract on 1st July 2024, according to which Mr. Gaurav had to supply 100 tons of sugar to Mr. Vikas at a certain price strictly within a period of 10 days of the contract. Mr. Vikas also paid an amount of rupees 70,000 towards advance as per the terms of the above contract. The mode of severe flood came on the mode of transportation available between their places is roadway only. Severe flood came on 2nd July 2024 and the only road connecting their places was damaged and could not be repaired within 15 days. Mr. Gaurav offered to supply sugar on 20th July 2024, for which Mr. Vikas did not agree. On 1st August 2024, Mr. Gaurav claimed compensation of Rs 20,000 from Mr. Vikas for refusing to accept the supply of sugar, which was not there within the purview of the contract. On the other hand, Mr. Vikas claimed for refund of 70,000, which he had paid as advance in terms of the contract. Analyze the above situation in terms of the provisions of the Indian Contract Act 1872 and decide on Mr. Vikas' contention. 4 marks.
See, now there is one seller who's selling sugar and he has to supply within 10 days. Now, within that 10 days, that buyer has given him 70,000 rupees as advance, correct or no? But within the 10 days, he could not supply because there were severe floods and the roads could not be repaired. So once there is severe floods and the roads cannot be repaired, what happens? This is called supervening impossibility. Remember? The contract becomes impossible of performing. And when there is a contract which becomes impossible to perform, it becomes null and void. What it becomes null and void. If it is null and void, both the parties should be returned to their original position. So that Gaurav, who's the seller, has to return back that 70,000. What he has to return back that?
70,000.
90,000.
Now, on 20th July, when you offered to supply the sugar and that fellow refused, he has every right to refuse it because now the contract has become null and
Void.
void. So he has no right to claim compensation of 20,000. The seller has no right to claim compensation of 20,000. And he also has to return the 70,000 rupees to the buyer because the contract has become null and
Void.
void. Understood or no?
Yes,
Understood?
sir.
Yeah.
Answer. Subsequent or supervening impossibility becomes impossible after entering into contract. When performance of a promise become impossible or illegal by occurrence of an unexpected event or a change of circumstances beyond the contemplation of parties, the contract becomes void. Example, change in law, etc. Also, according to Section 65 of the Indian Contract Act 1872, when an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it. In the given question, Mr. Gaurav and Mr. Vikas have entered into a contract to supply 100 tons of sugar. The event of flood occurred which made it impossible to deliver the sugar within the stipulated time. Thus, the promise in question became void. Further, Mr. Gaurav has to pay back the amount of rupees 70,000 that he received from Mr. Vikas as an advance for the supply of sugar within the stipulated time. Hence, the contention of Mr. Vikas is correct.
That's all.
Yes, sir.
Hmm.
Second one, R gives his umbrella to M during rainy season to be used for 2 days during examination. M keeps umbrella for a week. While going to R's house to return the umbrella, M accidentally slips and the umbrella is badly damaged. Who bear the loss and why under the provisions of the Indian Contract Act 1872? 3 marks.
This is a bailment. Remember bailment, gratuitous bailment. So when you give an umbrella, it is nothing but a bailment. So you'll have to define bailment. Now see, whenever what is the responsibility of the bailee? We did duties of a bailee, rights of a bailee, duties of a bailer, rights of a bailer. Remember? Now I don't have time to explain all that. But remember, one of the duties of the bailee, the person who's received the goods, even if it's gratuitous or non-gratuitous, he has to return the bailed goods in that reasonable period of time. Now, I had given him for 2 days. The stupid fellow kept it for 7 days. So, if you're keeping that goods for an unreasonably long period of time, even if there is no fault of yours, you slipped and the umbrella is broken, you have to bear the cost of the umbrella. If you would have slipped, let's say after 1 day, he's going back to return the umbrella, it slips and it falls with no fault of the bailee, then the bailer will have to bear the loss. But since he's kept it for a reasonably long period of time, now the bailee will bear the loss. Understood or no?
Yes.
Remember bail, pani puri, we did all this, no? Yes or no? Kachori, sambosa. This is bail. Bail mint. You know? After bail, you'll eat one mint chocolate. Okay, read.
Answer. Section 161 of the Indian Contract Act 1872 clearly says that where a bailee fails to return the goods within the agreed time, he shall be responsible to the bailer for any loss, destruction, or deterioration of the goods from that time, notwithstanding the exercise of reasonable care on his part. Hence, in the instant case, M shall have to bear the loss since he failed to return the umbrella within the stipulated time.
I told you if he is going on the second day and he falls off, if it's the exercise reasonable care, then the bailer only will bear the loss. Okay? Understood?
Yes, sir.
Okay, go ahead. Next.
B. What is a check under the Negotiable Instrument Act 1881 and who are the parties involved? What are the essential elements of the check? 7 marks.
Okay, good. So 7 marks comes from Negotiable Instruments Act. We'll see how much comes from negotiable. Because 6 marks come from LLP always. One question is guaranteed. One question from that law thing, that the duties, that is also negotiable instruments. Generally, 2 questions come, not more than 2. Anyway, we'll check it up. Next one.
C. What is the structure of Indian judicial
Nah.
system and what is the hierarchy of courts in India? 6 marks.
6 marks. So remember, 6 marks are pakka. One from judicial system, one from Lely. So 12 marks, you know. 7 marks we have seen Negotiable Instruments Act. We'll see how much more comes from negotiable later on. Understand? Go to
Yes.
question 5.
5A, under that first one. Avyakt purchased 100 kgs of wheat from Bhaskar at rupee 30 per kg. Bhaskar says that wheat is in his warehouse in the custody of Kishore, the warehouse keeper. Kishore confirmed Avyakt that he can take care of the delivery of wheat from him. Till then, he is holding wheat on Avyakt's behalf. Before Avyakt picks the goods from warehouse, the whole wheat in the warehouse has flowed in flood. Now, Avyakt wants his price on the contention that no delivery has been done by seller. Whether Avyakt is right with these views under the Sale of Goods Act 1930, 4 marks.
What you'll write? No, Avyukta is not right. You'll get 4 marks. Or yes, of course, Avyukta is right. How much they'll give you? 0. So first you'll have to write the meaning first of the facts of the case. Then you'll give the definition of delivery, voluntary transfer of possession. Then you'll mention 3 types of delivery. What are the 3 types? Actual, constructive, and symbolic. Here there is a constructive delivery. We've done this in the RTP, right? When one person acknowledges to the other person that he's holding goods on behalf of him and not on behalf of the seller, it is called as constructive. So here the warehouse keeper Kishore has acknowledged to Avyuk that he's holding the goods on his behalf. So delivery has been made. The property in the goods has got transferred. So the property in the goods has got transferred and delivery has been made. All losses will be borne by the buyer and not by the seller. Understand? No? So this Mr. Avyukt is absolutely wrong. He cannot claim any compensation. Correct? We did this in RTP, right?
Yes, sir. Answer. As per the provisions of the Sale of Goods Act 1930, there are 3 modes of delivery. First one, actual delivery. Second one, constructive delivery. Third one, symbolic delivery. When delivery is affected without any change in the custody or actual possession of the things, it is called constructive delivery or delivery by acknowledgement. Constructive delivery takes place when a person in possession of goods belonging to seller acknowledges to the buyer that he is holding the goods on buyer's behalf. On the basis of the above provisions and facts, it is clear that possession of the wheat has been transferred through constructive delivery. Hence, Avyukt is not right. He cannot claim the price back.
You cannot claim the price back. Very good. Next one.
Second one, classify the following transaction under the Sale of Goods Act 1930 according to the types of goods they are. A wholesaler of cotton has 100 bales in his godown. He agrees to sell 50 bales and these bales were selected and set aside.
Selected and set aside, ascertained goods. Specific and ascertained goods. Correct or no? So when the goods are set aside and kept selected and set aside from a given stock, they are called specific and ascertained goods. Remember USA? Unascertained goods, specific goods, and ascertained goods. So when they are selected and set aside, it's called specific goods, and ascertained, it's specific and ascertained. Okay, read it.
Answer. A wholesaler of cotton has 100 bales in his godown. So the goods are existing goods. He agrees to sell 50 bales and these bales were selected and set aside. On selection, the goods become ascertained. In this case, the contract is for the sale of the ascertained goods, as the cotton bales to be sold are identified under
Okay,
the
specific and ascertained. Second question.
B. A agrees to sell to B 1 packet of sugar out of the lot of 100 packets lying in his shop.
So these are not identified and separated. So what are they called? Existing unascertained goods. What are they called? Unascertained goods. Correct? Read the answer.
Answer. If A agrees to sell to B 1 packet of sugar out of the lot of 100 packets lying in his shop, it is a sale of existing but unascertained goods because it is
Okay,
not.
leave it. Yeah, it has not been identified and separated. Third one.
C. T agrees to sell to S all the apples which will be produced in his garden this year.
Future goods. They are not yet come into existence. No? So this is an agreement to sell for goods which will come or manufactured or will be produced at a later point of time. These are called, what are they called? Future goods. Right? Okay, leave that off. Next one.
B. When does dissolution of partnership firm
Okay,
take
suppose I
place?
give you one more type of goods. X agrees to sell all the coffee which will arrive if the ship from Australia, Sydney arrives on Chennai port, what type of goods are those?
Contingent goods.
Contingent. Understand? They are called as contingent goods. Correct or no? They have given all the other, they have not given contingent good. That's right. Okay. Okay, next one. This partnership leave.
C. Defined consideration. State the characteristics of a valid consideration under the Indian Contract Act 1872.
Oh,
6 marks.
very good. So definition, say consideration section 2D, right?
Yes, sir.
When at the desire of the promisor, the promisee or any other person has done or does or promises to do something. Correct or no? Remember? We had
Yes, sir.
given that definition section 2D, and then you'll have to give the essentials of a valid consideration must move at the desire of the promisor. Consideration may be made by the party or the third party. Correct or no? We did difference between stranger to consideration, stranger to consideration must be real and it must not be illusory. Correct or no? Remember we did all that? Very
Yes, sir.
easy question. This you can write on your own. Understand?
6A, first one.
Hmm.
Nakul made promissory note in favor of
How many marks?
Sahadev.
How many marks are this?
A sixth one, sir. 4 marks.
Okay, 6A1 and A2.
Uh,
Promissory note is negotiable instruments, right?
Negotiable instruments.
yes, sir.
Uh,
Second one, 3 mark question.
okay, so you are
Utkarsh,
getting this is 3 plus 3 or 6 marks, right?
4 plus 3.
4 plus
So that means negotiable instruments is coming. 2 questions are coming. 7 and 6 always in every paper, right? So we've identified at least the papers because contract act and company they keep on giving questions, but at least the smaller chapters you know how much are coming. LLP is 6 marks, judicial system is 6 marks, negotiable instruments 1 6 mark, 1 7 mark, right? Correct? In most MTPs and the previous year papers you'll find this. Understand? Got it? So 13, 19, 25 out of 120. Okay. Why 120? Because total is 6 into 20, right? Got it?
yes, sir.
Next.
Second one, Utkarsh purchased some goods from Saksham for rupees 50,000 on 14th August. Saksham draw a bill of exchange on Utkarsh and sent to him for acceptance on the same day at 3 o'clock p.m. Utkarsh requested Saksham to
This is
allow
also
him some, yes, sir, negotiable instrument.
3A and 6A and B both means.
Yes, sir.
Oh, that means this whole question is the negotiable instruments.
Yes, sir.
Sir, 6A1 and A2 is for 7
Oh,
marks. Like
yeah.
4 plus
And then, oh, this is A2.
Yes, sir.
Oh, not B, no.
No, sir, not B.
Okay, okay, then leave it. No, A will always be that. So the 7 plus 6, 13 marks is from negotiable instruments. You got it, right? Let's go to the next one. B.
B. Explain the terms trafficking relating to public officers and titles and stifling prosecution as per the Indian Contract Act 1872, 6 marks.
So you know what is trafficking in public office? When one person pays some money to another person to vacate an office or to obtain a office. Like for example, amount paid to get recruitment into the Indian police. And then we did one case also, Muttuswamy versus Swaminathan, where one person paid money to another to retire before his due date so that he could get the government job. Correct or no? The court held that, and afterwards the person refused to retire from his job. The court held that the contract was agreement opposed to public policy and it was null and void, right? So trafficking in public offices means trafficking in public offices, paying money to get a title like Padma Shri, Bharat Ratna, etc. What is stifling prosecution? I told you there are 2 types of offenses: compoundable offenses and non-compoundable offenses. If you deal by telling the other party not to file a suit against you for a non-compoundable offense, like trying to burn a person or throwing acid, this is stifling prosecution. What it is stifling?
Prosecution.
Basically, you're preventing him from prosecuting a person who can be dangerous to the society at large, right? Yes or no?
Yes, sir.
Right.
Yes.
So that will be also an agreement opposed to public policy, and it will be difficult. There are three terms which are used confusive. One is stifling prosecution, one is interfering with the course of justice, and one is restraint of legal proceedings. What are the difference between all three? Stifling prosecution is you pay money so that he doesn't file a case against you for a non-compoundable offense. What for a non-compoundable?
Offense.
For a compoundable offense, suppose somebody throws water on you, you tell him, give me 500 rupees, I won't file a case, okay. Suppose throws acid on you and you tell him not to file a case, it's a problem. What is interfering with the course of justice? Either bribing the judge or the lawyer of the opposite party or the public prosecutor or a witness to give the judgment in your favor or to give a evidence in your favor is called as interfering with the course of justice. What it is called? Interference in course of
Justice.
Justice.
interfering with legal proceedings or restraining of legal proceedings is when you enter into an agreement that the both parties say that we will not file a case against each other if we have a problem. Ambika has a partnership with Sana and she says that if there is any issue, you cannot go to court. That is interference in legal proceedings. So all those are also null and void except for arbitration. What except for arbitration? So remember there are three things which are used similarly, but they're totally different. What they're totally different. Understood?
Yes, sir.
Understood?
Yes, sir. Answer. Trafficking relating to public offices and titles. An agreement to trafficking in public office is opposed to public policy as it interferes with the appointment of a person best qualified for the services of the public. Public policy requires that there should be no money consideration for the appointment of the office in which the public is interested. The following are the examples of agreement that are void since they are tantamount to sale of public offices. First one, an agreement to pay money to a public servant in order to induce him to retire from his office so that another person may secure the appointment is void.
Muthuswamy versus Swaminathan. Remember I told you this case. Yeah.
Second one, an agreement to procure a public recognition like Padma Vibhushan for reward is void. Stifling prosecution, an agreement to stifle prosecution that is an agreement to prevent proceedings already instituted from running their normal course using force tends to be a perversion or an abuse of justice. Therefore, such an agreement is void. The principle is that one should not make a trade of felony.
Felony means you can't trade of some wrong act which you have done.
The compromise of any public offense is generally illegal. For example, when a party agrees to pay some consideration to the other party in exchange for the latter promising to forego criminal charges against the former is an agreement to stifle prosecution and therefore is void.
Right.
Under the Code of Criminal Procedure, there is, however, a statutory list of compoundable offences and an agreement to drop proceeding relating to such offences.
For compoundable offenses, it's okay, but for non-compoundable offenses, it's not okay. Understand? Yeah.
Yes. With
Yeah.
or without permission of the court, as the case may be, in consideration the accused promising to do something for the complaint is not opposed to the public policy.
Okay, next.
C. Explain any six circumstances in detail in which a non-owner can convey better title to a bona fide purchaser of goods for value under the Sale of Goods Act 1937 marks.
This we did last class, remember? Non-owner sale by a mercantile agent, correct or no? Sale by a buyer who's in possession of the goods. Sale by a seller who's in possession of the goods. Remember, we did all these? Correct or no?
Yes, sir.
Certain conditions have to be satisfied. Then you'll convey a better title. Other acts, pawnbroker, insolvent. So we did 7 or 8 circumstances under which, even if you're a non-owner, you'll give it. Correct or no?
Yes, sir.
So now you all are confident. Correct, So that's all, right?
Yes, sir. That's it.
So that's what. So I've already told you all how do you go. Go chapter wise. When you're studying for your exam, I'll tell you this in refresh and relax again, but do this. If you are feeling nervous and difficult, your exam is on 13th, the first exam. The second exam is on 15th. 13th is a Friday. 15th business law is on a Sunday. So what do you do? When you come back on 13th, rest for a little time and start studying. Finish off the easy chapters so that you feel that you're comfortable. Finish off the, what is that, LLP, legal procedure, negotiable instruments. So at least you know that you're finished three chapters. Because otherwise, if you start with Contract Act and then suddenly on 14th, 7 o'clock evening, you realize that you're finished only Indian Contract Act, then you'll start getting panicky, you'll get vomiting. So finish off those chapters which you think are easy first, so that at least you feel that out of 5 chapters, I finished 3, I finished 4. Then you won't get so nervous. What, you won't get so
No.
nervous. Understand? So do that. Prepare well. We'll meet one day on 13th, I think so. We'll meet for refresh and relax, hopefully. So all the best for your exams. And how many are attempting now? Just raise your hands out of these 70. 60. How many are there? Ambika, Ambu.
Yes, sir. Out of 82, 38 members are
39.
39.
39. 50% are attempting. Keep it up.
40.
40, 40. 40, 40. Just missed. It's not a holding company. Just understand? So the
Yes.
subsidiary company, all of y'all please relax and all the best. We will see you in CA intermediate. We'll see. I'll talk to you all again on the refresh and relax day. Okay? Thank you so much.
Sir,
Now all of
Jani Vatsal
Has
raised
raised
his hand.
Sir,
Jani Vatsal?
while referring to the case, any of the case in answers, it's okay if we write the name or we should write the year also, sir. Year of the case.
No, just mention the case. Year and all who'll remember.
Okay, sir.
Just mention
Thank
the
you, sir.
name of the case, it's more than enough, Jani.
Okay, sir.
See, if you mention the name of the case, 100% marks. If you
Okay, sir.
mention the name of the year, this is like Mehul sir, 100% focus, then it will become 200%. You mention also the AIR number, the case number, 300%. But for more than 200, 300%, maximum marks will get 1 mark only. So they won't give you 2 or 3. If the question is on 3 marks, they'll give you 3. They can't give you 5, no?
Yes, sir.
Even if you have 300% focus. Correct or no? Got it?
Yes, sir.
Got it? Okay. So now all of you,
Okay, sir.
right? I know 10 minutes are left, but I think so I will wind up the class now. Please stay tuned. 8 o'clock is Mayol sir, right?
Yes, sir. He already
Yes.
joined.
Yeah. Okay. So please, Mayol sir, you're joined. Congratulations.
Thank you, sir.
They are telling they have to mention the year of the case and the AIR number. I told that's not necessary, right?
Agreed, sir. Just in case if they remember, then nothing like that.
Remember, yeah. If you remember, Solomon versus Solomon, you remember the year? 1875. Okay, that is okay. Some of them are you can remember easily, but the others are not so easy, or they're not so. I've done hundreds of cases with you all. So Hadley versus Baxton, and I told you the important cases. Please remember Moiri Bibi versus Dharmadas goes, Hadley versus Baxendale. Those are the ones which are mentioned in your textbook, correct or no? But you still don't have to remember the. I don't think so. You'll have to remember that. They won't give you more marks for that. They will give you the mentioning the case will be okay, and mentioning the provisions of the act, the section is okay. But year and all is stretching it a little. Even in the answers, they've not given the case. No, just see the answer now, Ambika. When they read the MTP, that Solomon versus Solomon, did they give the year? No. In the
No, sir.
corporate,
No, sir.
no, they've not given. So even in the model answer, they've not given, so they won't expect you to do that. Okay. Now, Mehul sir is with you all the best, and all of you all. Bye. I'll meet you during refresh and relax. Correct? No? Me and Mehul sir both will meet you during refresh and relax. So that time I can. Or Mehul sir, we'll meet them then, no?
Definitely. Yes, sir.
Definitely, we'll meet them in refresh and relax.
Yes.
You can start if you want immediately. I'm exiting the class. It's okay, right, Mehul sir?
Definitely, sir. I will
Okay.
start in another 5-10 minutes. That's it.
Okay, you can start in 5-10 minutes. I'm exiting the class, all of you.
Sure,
Got it?
sure, sure.
Okay,
Yes.
thanks, all
Thank
of
you.
all of you. Thank you so
Thank
much.
you,
I'm
sir.
Thank you, sir. Bye,
Yes,
sir.
sir.
Thank you,
Thank you,
sir.
sir.
Audible?
Yes, sir.
Yes, sir.
Yes.
Visible?
Yes.
Yes.
Yes, no. Somewhere there, can't understand what this guy
Yes,
is
sir.
talking about. There?
Yes, sir.
Yes, sir.
Now, next time if I ask something, you don't have to shout. I understand that. Relax. All right? So, let's get started.
Yes, sir.
Tiring?
Yeah.
Back-to-back sessions, too much to handle, blah, 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 blah. All the emotional pool that you guys might be playing with yourself. Relax. All right? That's how it is. This is just a part of the journey. It's glad that imagine now let's take one step back. Imagine if you clear this examination, all the efforts that you have put in will be worth it. Will be worth it. All right. First of all, you've taken a quick step to getting at intermediate. Now imagine amidst all this effort is worth it, provided the moment you get your examination results, it's passed, done. All right. What else can you ask for? Listen to me very carefully. All right. Lot of people around you might be unnecessarily creating a lot of unnecessary pressure. Your parents, siblings, all those XYZ people whom you really don't care about, but still, yes, they are going to put unnecessary pressure. That auntie who has never spoken to me till now wants to talk to me now and ask how my exam preparations are going. Who cares? Nobody's bothered about it. We all love one cricketer, all right? Each one of us, whether you agree or disagree, all right? Even if you have that 1% inclination, it is as good as you love that cricketer. And according to me, that is MS Dhoni. The reason being, sir, however bad the situation is, that guy is just so calm, composed here. And that is exactly what each one of us are attracted towards him. All right. When I say attracted, I mean we love watching him play cricket. That is exactly what we guys have to do, guys. For the next 10 days, don't unnecessarily carry the burden which somebody else wants to put on your shoulders. All right. You have to carry yourself as calm and composed. The moment somebody is calling you or asking you, it's good to see you put so much effort, blah, 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 you have to keep reminding yourself it's worth it. The moment I clear this examination, this attempt, all of this is going to pay off. All of this is going to be worth seeing my pass and pass. All right. Luckily, you just have one pass because you have only 4 papers. So, having said all of that, what we are going to do is next 1 hour, 1.5 hour that we spend, we're going to just brush upon important concepts. All right. I will not be covering the entire syllabus. I don't want to. I want to just touch upon those important concepts which might be relevant from your examination. All right. So, those of you who are sitting here with all scared faces, don't scare me first. All right. The moment I look at you, I get scared. Relax, guys. You've been writing examination from kindergarten. Have you ever asked yourself, will I clear that third standard examination? When I was in 4th standard, did I ask myself ever thinking that will I clear that examination? No. Keep telling yourself every time, I will clear this examination, this attempt itself. No second thought, no unnecessary distractions. All right. Next 10 days, just take care of yourself as much as possible. All right. Don't fall for any stupidity, falling sick and all of this, because imagine you fall sick and all of the efforts will go for a toss. So that is in your hands. That you have to take care. Is the screen visible to everyone?
No, sir.
No, sir.
No,
All
sir.
right. So
No, sir.
what we are going to do is I will quickly project the screen. This is the revision material that you guys have got. All right. So I will just be touching upon important concepts. And I just want you to sit peacefully, close all your books, nothing to write. You are sitting in a PVR show. Somebody is yelling, although the movie is not interesting. It's okay. All right. Every movie which you've gone wasn't 10 on 10 for you. You remember that worst movie which you saw? This is one of them. Simple. Close all your books, sit peacefully, relax, listen. What we're going to do next 1 hour, just get as many concepts as possible clear in a pictorial memory, in the vision. When is your examination? It's going to be on a Sunday. Sunday for the world, but you know, for you, it is just another day. So you will have to go ahead and write examinations accordingly. Let's get started with the first chapter. Indian regulatory framework, 0 to 5%. Chiller cakewalk topic. Focus, everyone. Focus. So, Jivita. So, this topic, 100% you will have a question of 5 marks. Now, what kind of questions can they ask? They cannot ask anything outside the study material. All right. It's hardly 10 pages. So, how do you study this? The moment you come back home on the day after writing accounts examination, the first chapter which you're going to cover is this one itself. Easy. All right. On the day when you come back home after writing your accounts examination, you have to clear or you have to cover at least 3 chapters. Am I audible, everyone? Yes.
Yes.
Simple deal, nothing high funda. Simple deal, 3 chapters we have to cover. Now that 3 chapters should be such that I can easily cover 25 marks at least on that day, on the accounts examination day. Understanding? Is it possible? 100% possible. How do you begin? The first chapter is going to be Indian regulatory framework. Alan, there in the session. So we are talking about the first chapter. What kind of questions can they ask, or what is covered in this chapter? First, they are talking about what is law, what are the sources of law. What is law? Set of obligations which each one of us have to follow. All right. The main sources of your law comes from your constitution. The second one is all the statutes which they have passed out. All right. Important thing, power of the governments are distributed between state and center. So this entire topic is just giving you a flavor of from where can I get law and who's going to make the law. This is what we have to remember. Understanding? So when it comes to on screen, everyone. When it comes to law, all right, the entire legislature is divided between 2 people, center, state. Now, who's going to make what law, whether center is going to make, whether state is going to make, that is also simplified. How? By making 3 types of list: central list or union list, state list, and the third one is called concurrent list. All right. Now, what is the central list or joint list? Concurrent list is also called joint list. Now, what is this central list? Those which are going to be decided by the central government. What is the state list? That which is going to be decided by the state government. What is joint list? That which is going to be decided by both. So if this kind of question comes in examination, 100% we have to get 8 on 8 or 6 on 6, 5 on 5, whatever it is. How? Because the topic is so simple. The topic is just talking about what is law, from where is this law coming, and you have to remember the base of every law is constitution. I hope I'm clear, everyone. Understanding? Yes. So this is with respect to your law. Now, how do we make law, sir? I hope you remember the moment I talk about process of making law, there should be one picture which should come in your mind. Rajya Sabha channel, Lok Sabha channel, order, all right, please be seated. All the chaos, everything that you can think about a fish market, that is exactly how a parliament is operating. All right. So all the laws are made at the Lok Sabha. Then it goes to the Rajya Sabha. Then it is going to the president for the presidential assent. This is how the law is made. This is the process of making the law. Understanding, everyone? Yes. So the first one, when it is introduced, it is called as a bill. After it is passed in the official gazette, it will be called as an act of parliament. Understood? Next, what are the types of laws? 3 types of law: criminal law, civil law, common law. Now, what is this criminal law? Something which is governed by your Indian Penal Code or Code of Civil Procedures or Criminal Procedures. I'm sorry. When it comes to civil laws, this is governed by your Code of Civil Procedures. What is this common law? Case laws. All right. All the judicial precedents, all the case laws are called as common law. Simple, everyone? Understood? 3 types of law. Everybody, close your eyes. What is the process of making law? Parliament scene. What are the 3 types of law? Criminal law, civil law, common law. Simple, everyone. Understood? Yes, guys. Whether you believe it or not, our brains are tuned to remember things in a pictorial format. So as much as possible, try imagining things and create a picture of it in your mind. Easy to go about with your preparations then. Understanding? Yes, Danya. Principles of natural justice.
sir.
Now, what is this principles of natural justice? How do we remember this entire understanding? Do you remember Srivardhan there in the session? Somebody was asked to leave the session without asking him to leave or without giving him a reason. So what was his first question? Why should I leave, sir? What happened? All right. That is exactly the concept of principle of natural justice. You cannot go ahead and pass any decision without listening to the other person. You have to give the other person a fair chance to express and explain his matter. This is the whole concept of principle of natural justice. All right. How do we remember? This is nobody can go ahead and pass a decision or a rule until and unless the other person is given a chance. No one should be made a judge in his own case. Why will this come into picture? Because if I don't give a chance to Srivardhan, I will end up becoming a judge in their own case. I don't want to do that. That's why I want to give a chance to Srivardhan. Do you remember the example that we spoke about? Yes. So that he can explain, and after that, a judgment is passed. Sleepy? Next. Enforcing laws. All right. The laws will be made by the parliament. But who is going to implement these laws? By the various ministries. All right. So one of the ministry is called as Ministry of Finance. What kind of questions they can ask? Who has passed the maximum number of budget? Morarji Desai, 10 budgets. All right. So a couple of pointers which you will have to remember. What is the role of this Ministry of Finance? They take care of the treasury of the country. Very, very important. They take care of taxes. They take care of the financial legislation, all the financial institutions which are there, capital markets which are there, center, state finances, everything is taken care by this department called as Ministry of Finance. Clear, everyone? Next, we have something called as, under the Department of Ministry, you have a couple of points. Ministry of Corporate Affairs. Sleepy? Priya? Now, when it comes to Ministry of Corporate Affairs, they take care of very, very important administration of Companies Act and LLP and your Insolvency and Bankruptcy Code. 3 acts. Who's going to take care of this? Ministry of Corporate Affairs, corporate law, corporate affairs. What all are there in corporate law? Companies Act, LLP, Insolvency and Bankruptcy Code. Simple, everyone. These 3 are administered by a Ministry of Corporate Affairs. Here, everyone, understood? Next, you have something called as Ministry of Home Affairs. Now, what do they take care of? Very important, sir. They take care of the internal security and domestic policies. Within country, how should we maintain the security? All of that is maintained and handled by the Home Ministry. Simple, everyone, understanding? Yes. Now, who all are going to be there within this department? You're going to have border management forces. You're going to have internal security forces, Department of Home, Jammu and Kashmir and Ladakh. You have a Department of State and Department of Official Languages. All of these are various departments within the Ministry of your Home Affairs. Next, Ministry of Law and Justice. Now, when it comes to Ministry of Law and Justice, the name itself says, what is their role? This department is going to manage legal affairs. They're going to ensure that legislatives are implemented through the Department of Legal Affairs. All of this administration handled by Ministry of Law and Justice. Now, what kind of question? Favorite examination questions. Either they can ask, what is law? What are the sources of law? First question. Second question, they can ask, what is the process of making law and what are the types of law? Third question, they can ask, write a short note of various ministries. Ministry of Finance, Ministry of Corporate Affairs, Ministry of Home Affairs. Fourth question, they will give you various authorities like SEBI, RBI, IBBI. What is IBBI? Insolvency Bankruptcy Code. All right. So this whole board is going to be responsible for each of it. They can ask for a 2-marker, write a short note. That's it. These are the kind of questions which you can expect from this chapter. Simple, cakewalk chapter. Each one of you have to get this 5 marks in examination. Understood, everyone? Yes. So what is there in SEBI? SEBI means something which is governed under the ownership of Ministry of Finance. All right. What is the role of RBI? RBI is the central bank. It is going to be again under the Ministry of Finance. It is going to be for the purpose of controlling, issuing, and monitoring your Indian rupees. 2 important points which you will have to write is Bharatiya Reserve Bank Note Mudran. What is this? The authority or the division of RBI which takes care of minting money. All right. Where does this minting happen? 2 places. Nasik and Devas. These are the 2 places which by now you should remember. Why? Because we have discussed this time and again. Next, you have IBDI, which is Insolvency and Bankruptcy Board of India. What is their role? As the name itself suggests, they will help in insolvency proceedings. They will help in closing companies. It is going to cover for simple process of insolvency and bankruptcy proceedings. Who takes care of it? 2 authorities, NCLT, DRT. NCLT is National Company Law Tribunal. DRT is debt recovery tribunals. Clear, everyone? Understood? What is the structure of Indian judicial system? Is a simple point which talks about various courts. All right. How many courts do we have? Supreme Court, High Court, District Court, and you have one very important thing called metropolitan courts. Now, these are the only questions which can come from examination. That's it. This chapter is over, by the way. This chapter is over. 5 easy questions from this chapter. You can expect one out of these 5. Clear, everyone? What are the questions that they can ask? What is law? Second, what are the various types of laws? Third, process of making law. Fourth, what are the various ministries? Fifth, very important, they can ask about various authorities like SEBI, RBI, IBBI. Sixth, what is the structure of judicial system in India? What is judicial system? Supreme Court, High Court, District Court, and also Session Court. Why District Court and Session Court? District Court handles only your civil matters, and Session Court handles your criminal matters. And last one is called metropolitan courts. Metropolitan courts only in case if it is more for the population of 10 lakhs or more in a particular state. That's it. This is your first chapter. Confident? Getting some amount of confidence, everyone? Yes? 5 marks in hand.
Yes, sir.
Next, we go to the second chapter, which is called Pap of all topics. But I am assuring everybody sitting here is a pap of this topic. Indian Partnership Act. All right, everybody sitting here, I'm confident that we've done it really well during the session. You want to quickly see, all right, what all is covered in this chapter. 15 marks in examination. 5 marks already now. 15 marks is what we are doing right now. So on the date after writing examination, come back home, start with the first chapter. All right, start with partnership itself. Why? Because simple topic, you will be able to finish it quickly. Am I making sense to each one of you? Yes. So start with partnership, 15 marks already done. Second, start with the first chapter, which is your Indian regulatory framework. All right. 2 easy chapters will already finish your 20 to 22 marks in examination. You will get a lot of confidence because 2 important chapters ho gaya hai. Next 1.5 day, I will have to just spend on 4 or 5 chapters, small ones. Making sense, everyone? Yes. So let's get started now. What exactly is this LLP? I'm sorry, Indian Partnership Act, 15 to 20 marks. All right. When it comes to 15 to 20 marks of this chapter, Section 4. What is Section 4? Section 4 is partnership is a relationship between 2 or more persons who have agreed to share. Look at it. As simple as that. 100% one question will be there on the basics of partnership, like what is partnership, what are the elements of partnership. All of these are the basics. You can expect one question from this topic. 4 marks straight away. What is Section 4 talking about? Partnership is a relation between persons who have agreed to share the profits of a business carried on by all or any of them acting on behalf of all. The individuals are called as partners. Together, they are called as a firm. The name in which they run the business is called as firm. I don't think anybody sitting here would have ever had to memorize this. All right. It's a simple, straight point. Next. What are the quick thoughts? All right. Whether NGO, charitable institutions can become partnership? Answer is no. Can 2 companies start a partnership? Answer is yes. Can 2 partnership firms start another partnership firm? Answer is no. Why? Because there is no concept of separate legal entity. What are the elements of partnership? Copy paste of the definition, which is broken into 5 buckets. Easy. All right. There are a few case studies. Now, where I'll tell you where you guys will do a blunder. You'll read all the important points. You'll forget on reading the case studies. Case studies are very, very important. Please make it a point to ensure you read each and every case study, because in examination, they will ask you questions from case studies only. 4 to 5 marks straight away from case studies you can expect. Are you guys understanding? Yes. So what kind of case studies can they ask in case of partnership? They will ask case study to check whether it is a partnership or not. Example, co-renting a place. Me and Disha, both of us are owner of a property. All right. We have given it on rent to Diksha. Whatever rent we generate, can we say that Disha and me are going to be partners in a partnership firm, or all those questions which are revolving around Section 4? Answer is no, it is not a partnership firm. So you will have to evaluate, and that is exactly what is coming in the case studies as well. Getting some amount of confidence, everyone there? Yes. So you will have to ensure that you read the case studies. These examples are very, very important, friends. All right. Make it a point to ensure that you look at the examples. Then, to case law, Supreme Court rulings. All right. One is of KD Kamath, which is talking about essentials of partnership. The second case law is talking about Shanti Ranjan Das Gupta versus Murzamul. All right. Now, what is this Murzamul's case law? They are telling that, sir, 4 points you will have to check to come to a conclusion whether there is partnership or not. Check 4 points. First, records are there or not. Separate accounts are maintained or not. Bank accounts are there or not. Written notices are there or not. If these 4 things are missing, as per Shanti Ranjan Das Gupta, it is not a partnership. Simple. Understood, everyone? Yes. This is about your separate accounts. Coming to your partnership deed. Now, what is this partnership deed? Partnership deed is an agreement. If it is written and if it is stamped under the Indian Stamp Act, it is called as deed. If it is not written, then it will be considered as a verbal agreement. Is it acceptable? 100% acceptable. There is no problem at all. Understood? This is on the partnership deed. Coming on to the types of partner. Now, if you are lucky in examination, 100% possible. All right. They can ask a 5 marker on types of partners. First one, active partner, ostensible partner, or actual partner. Now, I'll tell you where you guys will make a mistake also. You will remember that active partner is also called actual partner. You also have to remember that active partner is also called ostensible partner. How they'll make the paper tricky, I'll tell you. All right. Write a short note on ostensible partner. Damar. Each one of us will start counting stars. So what is this ostensible? Estoppel partner and ostensible partner, same, one and the same. Right, estoppel partner story and come back home. Thinking that, okay, we'll get 4 marks now. Relax. First of all, blunder. Second, you didn't read it completely. Active partner, actual partner, also called ostensible partner. Example, on the other side of the screen that you have. All right. One who is actively engaged in the business of the firm, who participates actively in the conduct of the partnership, is called as an active partner. Now, very, very important in the examination when you're reading, all right, one day before examination when you're reading, please ensure that you also check liability. Tomorrow, if anything happens, is the active partner liable for it? 100% liable. Sell your house, sell your kidney, sell yourself, bring in the fund. Why? Because the liability of an active partner is jointly and severally liable. Sleepy?
No, sir.
No, sir.
To your sleeping partner, or again, sleeping partner is also called dormant partner. If you see on purpose in your material, I have given you the other names as well, because I know most of us will miss out here. All right. Sleeping partner, there in the session, is also called dormant partner. Their role is very limited because they will not be actively engaged in the affairs of the business. Tomorrow, if anything goes wrong, are the sleeping partner responsible? 100% yes, jointly and severally responsible. So when you're preparing an examination, friends, right next to this itself, keep writing. All right, in your material, I suppose you guys have already got the hard copy of this, all right, or soft copy, whatever it is. Have you got the revision material or not?
We got, sir.
You got it, no? Next to it itself, right next to it itself, you can just keep writing 1 or markers. All right, keep writing here itself. That will make your life easier. The next one is called nominal partner. Now, what is this nominal partner? Lends his name, all right, without having any real interest. He is not entitled to profits, does not take part in the business of the firm, but he is liable for all acts of the firm. Very, very important. Partners in profit only, as the word itself says, it is partners in profit, incoming and outgoing partners. And the last one is called partners by holding out, also Ananya, called S-triple partners. I repeat, this is also called S-triple partners. Sleepy?
No,
No,
sir.
sir.
Sure, everyone? All
No,
right.
sir.
Yes, sir.
Not sure? Brilliant. Let's go ahead. When it comes to relationship of the partners with others, all right, duties are important. There is one very interesting case study which you will have to read. When all the partners sell their shares, the partners who knows more about the accounts must disclose all the relevant information. There's a case study in your study material. Please read that. All right. Very, very important. Partnership property. Section 14. What all are the partnership property? 3 things. What we contribute as capital is the partnership property. Second, what the partnership acquires during its business existence is the partnership property. Third point, very, very important. Goodwill of the firm is also partnership property. All right. These are the 3 properties of the partnership firm. All right. This is under section 14. Section 16 talks about personal profits. Two things. If you have used the name of the firm, business connection of the firm, assets of the firm for carrying on any business, all right, any profits which are derived from such business have to be shared with the other partners also. Understanding? Second point, any partner who is carrying on a competitive business with that of the partnership firm, whatever profits you derive, you will have to share the entire profits with the partners of the firm. Section 16. You can expect, again, simple question on this as well. Section 16 is done. Section 17, rights and duties of partners after a change in the firm. What is this? Sir, whenever there is a change in the firm, when can there be a change in the firm? New partner is coming into picture, old partner is going out, or any such permutation combination. The rights and duties will remain as it was before the change until and unless you have made changes by an explicit discussion. Sleepy?
No,
Set
sir.
straight, everyone. Everyone, close all your books. I don't want anyone to open any books. No books need to be opened. You have to just focus while I'm talking right now. Nitya. All right.
Yes,
So,
sir.
section 17 says, sir, whenever there is any changes, whenever there are any changes, because of whatever reason, those 4 reasons which we have seen, the rights and liabilities will remain the same as it was before the change, unless you have agreed upon any change in the rights and liabilities. This is coming under section 17. Now, section 18, 22, very simple, very important. Partner is an agent of the firm. Since you are an agent of the firm, you get a superpower. What is the superpower called? Implied authority. I can extend or restrict this superpower against the third party. It will be effected provided the third party is aware of such extension or restriction. This is about section 18 and your section 20, 22, and 19. I hope I'm clear, everyone. Understood? Next. Notice to the acting partner, section 22. All right. If you have given, Alan, if you have given a notice to the acting partner, it is as good as a notice given to the entire partnership firm. All right. This is coming from section 24, and there are a couple of case studies here. Then liabilities of the partners, very simple. My favorite topic, section 30. Rights and duties of a minor partner. All right. Section 30
No
says,
concept of minor partner. They're being
getting some amount of confidence. Yes. Please note, simple chapter partnership is 15 marks in your kitty, provided you read that appropriately. Whatever we are discussing right now, you're just paying attention. All right. So when it comes to the whole discussion of minor partner or minor being admitted to the benefits of partnership under section 30, it says, so minor cannot become a partner in a partnership. So then what is this concept? Minor is only admitted to the benefits of the partnership. When you are preparing, you will have to pay certain extra attention on the rights before turning major and after turning major. Tanya, so before turning major, am I going to get a right to file a case against the partnership firm? Answer is no. As long as you're there in the firm, you cannot file a case. All right. Do I get a right to check the books of account? Answer is 100% yes. Example, everyone. What example? Do I have an access to books of account?
Yes.
Engineering and
Engineer. All right, a partnership firm where there are all engineers and I'm the only person who is from accounts background. Don't you think I will understand books of account more than them? All right. So that is exactly what we are talking about. Does a minor partner or a partner who is a minor being admitted to the benefits of partnership, can he get an access to the books? 100% yes. So these are a couple of rights when he's minor. Now the point is, once he turns major, Kirtana, once he turns major, two things. The day when he gets to know that he's been admitted as a partner to the partnership firm, or within a period of 6 months, whichever is later, the moment he gets to know that he's admitted to the benefits of partnership, he has to decide what he wants to do. If he wants to move out of the partnership firm, he has to give a notice to the world. If he does not give a notice to the third parties, then it will be presumed that he is continuing in the partnership firm. Once he is going ahead and continuing in the partnership firm, Vaishnavi, he will be responsible for all the debts and the obligations of the firm. His profit will be as it was before turning major, all right? And he will be personally liable for all the debts and obligations. sell your house, sell your kidney, sell yourself, bring the money. This is the whole discussion about minor partner. Next, legal consequences of incoming and outgoing partner. All right. If you want to add a new partner, all the existing partners have to agree to it. If you want to remove any partner, all the partners have to agree for it. Important thing that you will have to
No,
remember
majority.
there in the session, everyone.
Yes,
Yes, sir.
Very important, the liability of the partners. Incoming partner cannot be liable for things which happened before he came in. Outgoing partner cannot be liable for things after he went. All right. This is about your incoming and outgoing partners. Expulsion of partner under section 33. Example, quick. Expulsion of partner.
A and B
Part-
wife fought.
Party example.
Party example. All right. My wife, your wife fought in the party. Do you remember? All right. So in this case of expulsion of partner, you cannot expel a partner until and unless a notice is given, an opportunity of being heard is given. It is in the faith, in the good faith and the interest of the partnership firm. Until and unless these conditions are satisfied, even though you might have a majority of the partners, but still you cannot expel a partner. This is under section 33. Now, what you will have to remember is insolvency. Again, a simple topic. What is insolvency? In case if any of the partner becomes insolvent, he will not be a partner anymore. He will move out of the partnership firm. All right. Rights of the outgoing partner to carry on competing business. Those who are going out of the partnership. All right. Can he carry on a competing business? If the existing partners have put a condition on him, you will not do this business or a competing business in this particular period, in this particular area. Is it a restraint of trade? Answer is no. This will be an exception to the concept of restraint of trade, which you might have learned by from Rajdeep sir. All right, Rajdeep sir might have taught restraint of trade. One of the exception is in case of partnership. All right. Next, right of the outgoing partner in certain cases to share subsequent profits. What is this? In a scenario where I've left the partnership firm, but still, am I going to be getting a share in the profits after my exit also? Yes, provided your accounts are not settled. If your accounts are not settled, then you will be entitled to get a share in the profits. Sleepy?
No, sir.
No, sir.
So you will have to remember section 37, simple pointer, which talks about whenever there is an outgoing partner, he can share a percentage of the profit or 6% per annum, whichever is higher. Clear, everyone?
At the discretion of the
Not
partner.
higher, at discretion of partner.
During the session also, I yelled at each one of you. When it comes to subsequent profits, it is a share in the profit or 6% per annum at the discretion of the partner. There is no whichever is higher, whichever is lower here. I hope I'm clear, everyone. Understanding? When it comes to the share in the subsequent profits, it is at the discretion of the partner, not at the discretion of anybody else. Next, examples are there. Registration of firm. Is it mandatory to register a firm? What's up? The answer is no, it is not mandatory to register a firm. All right, can I register it later? 100% yes.
Yes.
What will happen if I don't register? Me here, Sleepy, three things. You cannot sue the firm or any other partner. You cannot file a case against the third party and you cannot claim a set off. Can a third party file a case against the partnership firm?
Yes, sir.
Even though it is not registered?
Yes.
Sir.
Yes,
sir.
100% yes. All right. A third party can go ahead and sue the partnership firm. Very, very important. Right to claim a set off up to 100 rupees is permissible. All right. These are a couple of questions which we have understood in case of registration. Now, what you will have to remember, again, very important, is difference between dissolution of firm and dissolution of partnership. You saw while we were seeing the mock papers as well as the RTPs, they've asked a question on difference between dissolution of firm and dissolution of partnership. Please don't expect entire 100 marker paper to be a bouncer. They will ask these kind of simple questions. Now, where is your smartness? Your smartness is in getting entire marks for these kind of simple questions at least. I hope I'm clear. I hope I'm clear. I repeat,
Yes.
I am not scared of those 1,000 moves which you might have practiced once. I'm scared of that one move which you might have practiced 1,000 times. Ensure that just because you want to cover the entire syllabus, You don't miss out on these kind of simple questions which are usually there in examination. 4 marks straight away. And if you remember, during the evaluation, recent mock papers which you have written, I hope you saw each one of you sitting here, how you have done there. Blunders in case of these kind of simple questions. You cannot afford doing that in examination. Clear, everyone? Of course, goes unsaid. I was being too strict for the evaluation, which will not happen in the examination. But having said that, please don't miss out on these kind of questions. Next, is the screen visible? Dissolution of partnership and dissolution of firm. Very important, you will have to remember dissolution of firm can be by 2 ways. One, by the order of the court. Second one, without the order of the court. You must have this chart imprinted in your mind. There is no option at all. It has to be stuck in your mind. There is not a single attempt in the past where I've seen without a question on dissolution. So you should be in a position to get marks easily here. Why? Sir, simple topic, sir. Where will the court pass an order? Where a court will not pass an order? This is exactly what is coming here. Section 40 to section 43 is talking about without the order of the court. Section 44 talks about the order of the court. Simple topic. All right. Now, what will happen in case if the firm is dissolved? All right. Liability for acts of the partner after dissolution. Can they be responsible for things done after the dissolution also?
Yes, sir.
100% yes. Why? If you don't give a notice to the public.
Notice.
Notice has to be informed that, public has to be informed that there is a dissolution of the firm. Rights of the partners to have the business wound up after dissolution. Once the dissolution is carried out, entire partnership can be wound up, entire business can be wound up, and it is the right which the partners have. Settlement of losses. Whenever you settle losses, how are you going to settle losses? And a couple of very simple pointers which are here. All right. Now, that is about your whole discussion on partnership. Confident about the chapter?
Yes.
Yes. Believe it or not, we ourselves have revised this chapter approximately 8 to 9 times. I hope each one of you are pretty confident of this chapter. All right. 15 marks, easy game. Next comes to the chapter called LLP. 5 to 10%. Now, how are you going to read this chapter called LLP? My simple way, suggesting on day 1, the moment you finish your first chapter, which is your Indian Partnership Act, regulatory framework, all right, take up another simple topic like LLP. Finish it then and there. Why? Again, 5 to 10% will be there in examination. On that day, just keep a target of 3 chapters, guys. Don't take up too much there. Just 3 chapters. What are those 3 chapters? Indian Regulatory Framework, Partnership Act, and LLP. How much will you end up getting? At least 35 to 40% of the syllabus ho gaya. All right, how 35? 20 marks, 15 marks at least in your this one, partnership, 5 marks at least in your first chapter, Indian Regulatory Framework. If you're lucky, you could end up getting 10 marks from this chapter. Chalo, let's be a little more practical. Let's assume 5 marks from here. You can easily get 25 marks sorted. Day 1 after examination itself, 25 marks in your hand. Sleepy?
No, sir.
In this chapter now, sir, what kind of questions that they can ask? Simple questions like what's the body, what are the characteristics of LLP? If you remember in your mock exam, there were 4 characteristics that they have given for an LLP, small LLP, not in the mock exam, I'm sorry. While we were discussing in one of the articles itself, they have given 4 types of characteristics: small LLP, foreign LLP, and they've given body corporate and mutual agency, a couple of characteristics. All right. Ensure that you remember the characteristics. Simple topics. It is, what is LLP? A bhel puri of what? Companies Act and Partnership. Take the advantages of both and give your answers. Now, my suggestion, worst came in the examination where you're not able to recall anything at all. This is how you can approach the questions for LLP. What could have been the advantage under Companies Act? What could have been the advantage under the LLP, under the Partnership Act? Take both the advantages, you'll end up with an LLP concept. So you will have to pay attention on the characteristics of LLP when you're preparing for exam. All right, simple topic. Body corporate, perpetual succession. Men may come, men may go, but LLP will go on forever. separate legal entity, mutual agency concept, LLP agreement is drafted, artificial legal person, common seal, limited liability, management of business by the designated partners, minimum number of members, or instead of members, it has to be partners. Minimum number of partners is going to be 2, maximum any number, business of profit only. Very interesting. Can I have LLP for charity?
No, sir.
Control your
No.
mouth. You can't. You can't. All right. Next, investigation can be carried out. Can 2 LLPs come together, merge, amalgamate into another LLP? Possible. 100%. Can I convert a company into an LLP? Possible. Can I convert a partnership firm into LLP? Possible. All of these pointers are there in your LLP topic. Very important for an LLP. What is this for an LLP? Am I audible?
Yes,
Yes,
sir.
sir.
An LLP which is incorporated outside India and has a place of business in India. Simple. Understood, everyone? Yes. Similar concept to that of foreign company. All right. While we were discussing foreign LLP, I had mentioned this to you. Very important. These days, they ask this question on small LLP as well. All right. They ask, what is a small LLP? How small is a small LLP? Ensure that you remember what is a small LLP. We'll see that. What are the advantages of LLP? Simple topic. What is a small LLP? Section 2, clause TA of the LLP Act. Remember, it has to be there at the tip of your tongue. This has to be there at the tip of your tongue. Understanding, everyone? Yes. So what is the small LLP? Section 2, clause TA of the LLP Act says where contribution is less than 25 lakhs or turnover is less than 40 lakhs, it will be considered as a small LLP, newly introduced topic. Similar concept exists under Companies Act, small company. They're aware of it?
Yes,
Yes,
sir.
Section 2, clause 85 of your Companies Act 2013 talks about small company. Small company means a company which has a paid up capital up to 4 crores, turnover up to 40 crores. Easy to remember. Here, small LLP means instead of using the word capital, I don't have a concept of capital in case of LLP, right? In case of company, I have a concept of capital. So their capital requirement is 4 crores. Here, instead of capital, we are using the language contribution. How much is the contribution? 25 lakhs. And when it comes to turnover requirement is of 40 lakhs or any other condition which may be prescribed from time to time. This is the whole concept of small LLP. Understood? Brahmi. Registration of changes in the LLP. Whenever there are any changes in the LLP, within 15 days, they have to inform the LLP. LLP has to inform the daddy within 30 days. Sleepy guys, sit straight. Take a couple of deep breaths. All right, sit straight. That's how you watch horror movies. That's how you watch flop movies, right? Now, this is what you'll have to assume and sit peacefully. 2 important conditions. Whenever there is a change in the partner's name or changes in the address of the partner, you will have to inform the LLP. Within how many days? Within 15 days. Within how many days will the LLP inform the registrar? Within 30 days of such change. If you remember the blunder which you did while we were solving the questions in examination, 15 days from the date of change, 30 days from the date of change. This is about your changes in the partners. Next, designated partners. Favorite examination question. What is designated partner or who is designated partner? Section 7. Every LLP shall have 2 designated partners. Both of them have to be individuals. Very important. Now, out of that, one shall be a resident in India. Now, who is this person resident in India? A person who stayed in India for a period of 182 days during the immediately preceding year. Chitranna, if you don't pay attention. OPC as a concept also you've learnt under Companies Act, where you had a person or the member and the nominee has to be a person resident in India. Do you remember?
Yes, sir.
There the condition is resident if he stayed in India for a period of 120 days. In case of LLP's designated partner, if he is staying in India for a period of 182 days. How to remember? Easy. Listen to me. Who came first, Rajiv sir or Neha?
Rajdeep, sir.
Very obvious. All right. I am his student. So it's obvious that I have learned things from him. So he came first. What comes first, 120 or 182?
120.
120.
Simple.
120.
Anybody saying 182 in the numerological series, 1 comes after 2? Writing CA examinations only, no? Everyone? 120 comes before 182. Clear, everyone? Yes?
Yes.
Same way, Rajdeep sir came before Mehul. So therefore, why Rajdeep sir and Mehul? Because, of course, Rajdeep sir came before Mehul. Rajdeep sir handled Companies Act. Mehul is handling LLP. Companies Act you come across only at one place, that is OPC, where the requirement of 182 days or 120 days is there. Clear, everyone? Yes? Close your eyes, quick. OPC, 120 days. LLP, 182 days. OPC, 120 days. Designated partner concept in LLP, 182 days. OPC, 120 days. Designated partner, 182 days. Clear, everyone?
Yes, sir.
Designated partner, 120 days. And OPC, 182 days.
Sir,
Clear with the
sir.
concept,
Other
everyone?
way
No, no,
around,
no.
sir.
No,
No, sir.
Look at your friends. Look at your friends. You forget about me. All right, look at your friends. Yeah, they're just nodding. They're closing their eyes and nodding. Ah, yes, sir. That is also correct. Thanks. All right, let's go ahead with the next point. All right, designated partner is done. Very important concept which you will have to remember in a scenario where all the partners in an LLP are body corporate. Then in that scenario, what will you do? In that scenario, you will have to ensure those body corporates will send a designated partner who is an individual as a nominee, as a representative of the body corporate, and such individuals will become the designated partner. Understood? This is something that I discussed. Tata Limited, Bata Limited are shareholders, are partners of Batata LLP. Now, how can I have designated partners, Tata Limited and Bata Limited as the designated partner? Not possible. Why? Because designated partner has to be an individual. So what I will do, Tata Limited will send one person, Bata Limited will send another person as their representative, and those individuals will become the designated partners. Clear, everyone? Hiranmai there, Tanushri there. Next. Very, very important. The explanation of 182 days during the immediately preceding year, the word 120 days shall be substituted. All right. What is the meaning of this? In the explanation for the words 182 days, now they have substituted with 120 days. To make your life simple, we have discussed this. Don't glare as if you're listening to it for the first time. Sit straight. Both Rajdeep sir and Mehul are teaching law, and I can't have the variety within law. So everybody have to consider 120 days. Understood? So all that Chitrana which you had about 120, 182 days has been now resolved. Now you have only 120 days. Clear, everyone? OPC, 120 days. Designated partners, 120 days. Clear with the concept, everyone? Understood? Why I have given this whole Belpuri is because in examination, they will ask questions. And I don't want you to get confused anywhere. Simple. OPC, 120 days. Designated partner, 120 days. Clear. Now, no more 182 days. That is exactly what is coming from the amendment as well. Clear, everyone? Understood? Yes. Now, coming to your liability of the LLP, simple pointers. All right, changes in the name. Whenever there are changes in the name, how do you go about? This has been asked in the recent attempts. All right, I will not be surprised if there is a change in the name as a question. Whenever there is a change in the name, law says please inform your registrar. Something that you should already know. Apart from that, what if I've taken the name of another LLP which is already existing, or if I've taken a name which is similar to a trademark which is already registered under the Trademarks Act? So what law says? If you want to voluntarily make changes, please go ahead, make changes. All right. If you don't make changes and somebody else wants to go ahead and make an application, then that person has to make an application within a period of 3 years from the date of incorporation. Do you remember the example of Maggie LLP? I want to start an LLP called as Maggie LLP. Now the point is, can I start something of this sort? Law says, no, you can't. Why? Because it is similar, identical to another trademark which has been registered under the Trademarks Act. No, sir, I will still take it. Take it. In that case, If Maggie, if Nestle files a case against you, making an application to the central government, asking central government to direct you to change your name, you will have to change your name. Within how many years can Nestle make an application? 3 years.
3 years.
Do you remember this, something that we had discussed in detail? Yes, Abhay there. Understood, confused, convinced. Silence. All right, extent of liability, something that we have already spoken about. Unlimited liability. Again, these are topics which might not be asked in examination. All right, just as a casual reference, you can pass because right now it is not there as a part of your syllabus as well. Now, what is important? All of these were there earlier, might not be important. What is important is differences between LLP and partnership, differences between LLP and companies. 100% you must know each and every word of these differences. Differences between LLP and partnership, differences between LLP and company. With this, we come to an end of 3 chapters. All right, we have revised 3 chapters, if you realize, in a span of 47 minutes, 45 minutes, if you were to ask me. All right, possible hai, 100% possible hai. Understood? The last chapter, Negotiable Instruments Act. You remember, no? You have a chapter called as Negotiable Instruments
Yes, sir.
in your syllabus.
Yes, sir.
The way you guys are looking at me, I am getting scared. Now listen to me, guys. On day 1 itself, like I've already mentioned, finish these 3 chapters which we have just revised, fresh there in your mind. All right, easy chapters. You know the kind of questions that they can ask. We've solved a couple of RTPs, we've solved a couple of mock papers. So you guys have a flavor idea of what kind of questions they can ask in the examination. All right, understanding? Now, am I audible to everyone?
Yes, sir. Yes, sir.
So what I want you to do is ensure that the moment you come back home, partnership done, Indian regulatory system done, all right, and your LLP is also done, 25 marks done on the same day. Negotiable instruments, listen to me very carefully. How do you approach this chapter? Take up this chapter. At what time are you going for your examination? What time is your examination? In the afternoon, right?
Yes.
What time?
1:45
Like
to
it starts from
1:45 to 5 o'clock. That's the whole time, right? Now, negotiable instrument, this one chapter, you read on the date of examination itself. I repeat, negotiable instrument, this one chapter, don't read on the first day, don't read on the second day, you read it on the last day, on the date when you're going for your examination. Are you guys understanding? Now, doesn't mean that if you've already finished the syllabus on the second day itself, still you'll wait for the next day morning. No. If you finish the syllabus, complete this chapter also. Why I'm asking is because Indian Contract Act, Sale of Goods Act, and Companies Act will take your entire day on the second day. It's huge. It's voluminous. All right. So ensure that you spend good amount of time on day 2. That is the day when you have that entire day, right? Spend good amount of time and cover the entire those 3 chapters. The only chapter then you would be left with would be negotiable instrument. 3 to 4 hours, more than enough for negotiable instruments. From 8 o'clock up to 12 o'clock also, if we sit and read, 4 hours, more than enough to cover negotiable instruments. Clear, everyone? Understanding? Approachable? Yes. But if you have already covered the entire syllabus on the second day itself, don't wait for the next day morning. Please finish negotiable instruments also on the same day so that on the date of examination, you don't have tension. Now, what is this chapter called negotiable instrument? First of all, simple topic, all right? Don't unnecessarily create panic by thinking that it's a topic which I might know, I might not know. No nonsense. Again, is the screen visible to everyone?
no, sir.
All right.
Now, yes.
It's an easy topic because you've already learned this topic in accounts. Do you agree?
Yes.
Yes, sir.
Yes, sir.
Accounts there in your syllabus, right? It's a part of your curriculum.
Yes, sir.
Yes.
Negotiable instruments discussed there.
Yes, sir.
Yes, sir.
So this chapter is a revision of accounts which you've already written in examination. All right. So to that extent, you already should have the confidence that you'll be able to easily write the answers to this question. Now, what all are there in this chapter? What all should we cover as a part of topic? Let's quickly discuss. Is the screen visible to everyone? Yes?
Yes, sir.
Yes, sir.
All right. Negotiable instrument. Very, very important topic. All right. 10 marks minimum from this chapter. 10 marks minimum from this chapter. I'll not be surprised if they end up asking more than that. Important topic. They will not ask too many high funda questions, but they will definitely ask questions which will require usage of brains. All right. So you will have to read the question at least thrice and then attempt the questions from negotiable instruments. I repeat, at least thrice you should read this chapter, the questions from this chapter, and then attempt the examination question. You have two advantages. One, you've already come across this topic in accounts. So when you were reading accounts itself, you would have covered the basics. Second advantage, questions would be simple. It's just that they will play around with small tricky portions of the question. They will make something slightly confusing, and then for that you will fall. But on an overall level, questions will be simple in this chapter. Am I making sense to everyone? Yes. So let's go ahead. Let's spend some time on negotiable instruments. 10 to 15 marks asked in examination. First point, what is negotiable instrument? Negotiable instrument means any document which can be used for the purpose of transferring the titles. All right, for the purpose of transfer of the titles or ownership from one person to another. In simple terms, definition is coming from section 13, which says promissory note, bill of exchange, checks. As simple as that. That's it. My answer ends here. Correct?
Payable
No.
to the bearer or order.
This is exactly the mistake which we do in examination also. Negotiable instrument means promissory note, bill of exchange, checks. Come back home thinking that you've got 4 marks. Nonsense. They'll not give you 0 for this. Because your answer is revolving around the phrase payable either to the order or to the bearer of the instrument. Am I making sense to everyone? Understanding? Yes. Please
sir.
make it a point to double check your answers when it comes to negotiable instrument. Next point. What are the negotiable instruments that we have understood? What are the characteristics of negotiable instrument? One of the RTPs is having a question only on writing characteristics of negotiable instrument. What are the characteristics? It has to be in writing. It has to be signed. It should be freely transferable. It should be ensure that the title is not defective. It can be transferred any number of times. It must be either a promise or an order. The promise or the order should be for making certain sum of payments. That's it. These are the characteristics of negotiable instrument. Make it a point that you know each and every word of the characteristics. Next, there are 2 important definitions, all right, or rather 3 important definitions. Promissory note. Section 4 defines promissory note. What is it, Shekhar? Section 4 says a promissory note is an instrument in writing containing an unconditional undertaking signed by the maker to pay a certain sum of money to the bearer or to the order of the instrument. Very, very simple. Or to the order of a certain person or to the bearer of the instrument. What is this? Nothing but characteristics written again. If you were to see, it is nothing but the characteristics which are written again. Banknote, currency note is not included within the definition of promissory note. I hope you remember banknote, currency note on screen. All right. Yes, this is about your promissory note. There are a few case studies which are there. All right. I want to make a point. Ensure in negotiable instruments to get the maximum marks, you read as many case studies as possible and then go. They will ask questions only revolving around the case studies itself. Negotiable instrument, mainly they will ask questions revolving around the case studies. Where are these case studies, sir? In study material, they have a plethora of case study. In CAPS material also, pretty much we have covered those case studies. All right. So this is about your promissory note. Second point is on bill of exchange. Now, what is this bill of exchange, sir? Again, section 5 defines bill of exchange is an instrument in writing. Same characteristics again reproduced. Here, the only difference is it is an unconditional order. There, it is an unconditional undertaking. All right. Can you see here, everyone? There, it is. Here, it is an unconditional undertaking. Here, it is an unconditional order. Clear, everyone? Understood? Now,
Yes.
section 6 talks about check. Now, what is a check? Check is a bill of exchange itself. All right. Which is going to be payable only if it is demanded. And this also includes 2 types of check. One is a truncated check and the other one is a check in an electronic form. These are the two types of check. We've understood what is a truncated check, what is an electronic check. All of this we have discussed during our session. Coming back to the next one, holder and holder in due course. Who is a holder? Holder is a person who, in his own name, has all the right to receive or recover the amounts. As simple as that. All right. Ambika, any person who is entitled in his own name to receive the amount or recover the amount is a holder of the instrument. Section 8. What is section 9 talking about? All right. Section 9 talks about holder in due course. Who's this person? Holder in due course.
Who transfers the bill is
Abhimanyu.
Brilliant. All right. You remember Spider-Man, Batman, you remember Abhimanyu. All right. The whole discussion, guys, there was a reason why I've shown those pictures. Look at it. It just sticks in your memory like anything for that matter. You will not forget these concepts. So when it comes to holder in due course, so don't undermine your memory. Keep appreciating it every now and then. Look at you. You guys are able to recall the examples as well. Holder in due course means any person who has become the owner or the possessor of the instrument for a consideration and who has got it without any defect. All right, he who has got it with the belief that there is no defect in the title of the instrument. Simple point. All right, Disha, what are they saying? Who's this holder in due course? He's a person who's the holder. He's a possessor of the instrument. First point. Second, how did he get this instrument? Because for a consideration. Third point, he does not have any reason to believe that there is a defect in the title. That's why once it passes through my Superman, Spider-Man, if you remember, all the defects are removed. All the defects are purged. That is the language that we have learned. Except forgery. Except forgery. Understanding everyone? Yes. So that is an exception to the holder in due course as well. Next, we went on to understand classification of negotiable instrument. Often asked in examination for a 4-marker. What are the classifications of instrument, negotiable instrument? They can ask you write a short note on ambiguous instrument. They can ask you write a short note on foreign instrument. What are all this? Close your eyes. Simple way to remember. Negotiable instrument, 4 types. First one is called order or bearer instrument. Second one, Likita, is called inland or foreign instrument. Third one, very important, it's called inchoate or ambiguous instrument. The fourth one is called, what is the fourth one called?
Ambiguous.
The third one is inchoate instrument, and the fourth one is called as ambiguous instrument. Now listen to me very carefully. All right. Now, what is order or bearer instrument? Order instrument, whose ever name is written, that person is the owner of the instrument. Only that person can get the rights. Sit straight, everyone. Open your eyes. Oh, seems like you guys have fallen asleep. Bearer instrument. Guys, this is how flop movies are. You have to pay attention also. You paid for the ticket, right? Now listen to it. Bearer instrument, whoever has the ticket, whoever has the instrument is the person who is going to enjoy the rights of the instrument. Foreign instrument, inland instrument. It is an inland instrument if 3 conditions are satisfied. What 3 conditions? Made in India, drawn in India, made payable in India. If all the 3 conditions are satisfied, then it is an inland instrument. If anything is missing, it is a foreign instrument. What is inchoate instrument? Incomplete instrument. Something is missing. Classic example. You would have made this instrument. Something has to be missing in it. All right. Such instruments are called incomplete instruments. What is ambiguous instrument? Sir, complete life, sir. Confusion. Even I don't know what it is. How? Whether it is a bill of exchange or a promissory note, I don't know. That is the whole ambiguity. That is whole confusion. Such instruments are called as ambiguous instruments. All right. An instrument where there is an uncertainty, where there is an ambiguity, whether it is a promissory note or a bill of exchange, such instruments are called as ambiguous instrument. Simple. Clear, everyone? Understood? Yes. Next, negotiations. All right, where you will have to pay extra attention. Listen to me. Section 138. All right. Now I'm emphasizing on important topics. Pay attention. Section 138 talks about check bounce. All right. What is this whole concept of check
There's
bounce?
no concept of check.
No check bounce.
Tanushree, there is no such concept called as check bounce. People are just in a wave saying, yes, sir, check bounce. All right. Check being returned due to insufficiency of funds. Section 138. Now, what is section 138 saying? So, due to insufficiency of the fund, if your instrument is dishonored, why it is returned? Because two conditions. Either you don't have sufficient money, all right, or the amount exceeds the arrangement which you made with the banker. If you told the banker not to pay more than 10,000 rupees, you might have money in your bank account. But since you've given an instruction to the banker not to make more than 10,000, let's assume you've given a check of 20,000 to me. That check will be thrown back on your face. Why? Banker says, I have a standing instruction that it cannot be gone ahead with more than 10,000. Two scenarios, guys. When can section 138 come into picture? First, where there is insufficient balance. Classic childhood or classic student life. Money is never sufficient at all. Why? You get 500 rupees to spend the entire 30 days. How under the sky? I don't know. Second thing is where there is an instruction given, amount is there, all right, but the amount given on the check exceeds the amount with which you have an arrangement with the banker. If you told the banker not to make the payment of more than 10,000, and if you've given a check of 15,000, the check will be thrown on your face telling that there is an arrangement with the banker and this amount exceeds the arrangement amount. Understanding? In this case, the instrument is returned due to insufficiency of funds. As simple as that. Now, what will happen? Penalty. All right. There will be a penalty. How much is the penalty? Penalty is going to be imprisonment for a term of up to 2 years or with a fine which may extend twice the amount or congratulations. You've got a scratch card. Both. Imprisonment bhi jao as well as the pay the penalty. All right. Pay the amount. Both are there. Now, this is section 138. But wait, section 138 cannot be gone ahead if three conditions are not satisfied. All right. You will have to satisfy these three conditions. Only then a penalty will be levied, or else you cannot levy a penalty. What are these three conditions? First one. All right. The check has been presented within the validity period. If you have not presented the check itself, you've given a check to me. All right. If I didn't go to the banker and present it within the time, can I file a case against you because of insufficiency of fund? Answer is no. Second, even though the check is returned, all right, there is a demand for the payment and notice has to be given within 30 days. All right. You will have to inform, or I have to inform you within 30 days that the instrument has been returned. Now, after I give a notice to you, within 15 days, if you made the payment, then I cannot go ahead with section 138. No, if you have not made the payment to me within 15 days, then I will go ahead file a case. For those of you who are still counting stars, let me quickly repeat. Is the screen visible?
Yes.
Yes, sir.
Let me know if the screen is visible. Can you see the MS screen? Yes?
Yes, sir.
Yes, sir.
Yes, sir.
Let's assume, all right, you have given an instrument to me. Now stop deciding and judging my drawings. I'm not an artist, so listen to me. The whole point is section 138 can be triggered, a penalty can be triggered only if three conditions are satisfied. What are the three conditions? First condition, have you presented the instrument within time? Answer is yes, I went and presented the instrument within time. Second, I have given a notice. Let's assume the instrument has been dishonored because of insufficiency of fund. I have informed you within 30 days. Third, after the second condition, after me informing you, you have made the payment within 15 days. If you have not made the payment within 15 days, then section 138 can be triggered. If you made the payment within 15 days, why will I ask you for a penalty? There's no question of penalty. That's enough. Understanding everyone? Yes, this is about your section 138. Next. Presumption in the favor of a holder, couple of very simple pointers. All right. Presentment. Very, very important topic. All right. 100% focus on this important topic. Now, what is the presentment, sir? Although it is important, doesn't mean it is high funda. Relax. Presentment means I have to go give it to you on the due date so that you can make the payment to me. Understanding? Simple as that. Yes. Let's assume you have given a promissory note to me. There are two types of presentment. One for acceptance. Second one for payment. For acceptance means where you have given a promissory note to me. All right. I have to accept it, only then it is going to be complete. Second scenario, presentment for payment. On the due date, congratulations. I am coming back to you. Make the payment now. Here, there will be a presentment for payment. First time what happened? Presentment for acceptance. Now what is happening is presentment for payment. Now, what can be asked in examination? What they usually ask in examination is scenarios where presentment is not necessary. Are you guys understanding? Everyone there? Yes. Section 76 says scenario where presentment is not necessary. What are those scenarios? 4 important scenarios. Just pay attention on this. First scenario, I'm not able to find you at all. All right. You're not there during the business hours. You're not there. You're not visible at all. How will I come and give it to you for presentment and acceptance? First scenario, not possible. Understanding? Second scenario, where against any party sought to be charged, he himself has engaged to pay notwithstanding presentment. What does he say? Sir, don't worry, I will make the payment even if you don't present. On the day when I have accepted it, at that time itself you've told, sir, notwithstanding your presentment. What is the meaning of the word notwithstanding? Even if you don't present, still I will make the payment. Then should I present? Obviously, you don't have to present because he himself has told without presentment, he will still make the payment. This is the second scenario. The third scenario, as against any party, if after maturity, he makes a part payment. Now, what has happened? Very interesting. I didn't present, but still he has made a part payment. Say 10,000 rupees had to be paid. He's paid 2,000 rupees. Even if I didn't present, still he made 2,000 rupees. Then for the balance 8,000, do you really want me to present again? Answer is no. Then why did you make the initial 2,000 rupees? You should have rejected at that time itself. This is exactly what law is saying. If you made a part payment, there's no question of any presentment to be made for the subsequent balance. The last one, as against the drawer, if the drawer could not suffer any damages for want of presentment, even if I don't present, will you suffer a damages? If the answer is no, then why do you want a presentment? In these 4 scenarios, presentment is not necessary. Clear, everyone? Understood? Now, very important. All right, they ask for a case study of 48 hours. Now, what is this 48 hours? Pay attention, everyone. Is the screen visible to everyone?
Yes, sir.
Yes, sir.
Yes. Now, whenever I give any instrument for payment, all right, or any instrument for presentment, it has to be done within a period of 48 hours. Section 63 clearly says, if you allow more than 48 hours to anybody to accept the instrument, the other parties are discharged. What is this? For those of you who didn't understand, Punyashri has given an instrument to me. I have given it to Tanushree, Tanushree to Hiranmay, Hiranmay to Mihir, Mihir to Kirtana, Kirtana to Disha. Disha has gone ahead and given it to Ambika to accept it more than 48 hours. Law says, who asked you to give more than 48 hours? Did you ask us? Answer is no. Now we will not make the payment. You cannot give more than 48 hours to anybody to accept the instrument. All right. This is the whole concept of draw is time for deliberation. Next, you might have to read all of these up. The last point is rules as to compensation. 117. Section 117 says the compensation in case of dishonor. All right. We have made full fancy check. We have made full fancy promissory note, full fancy bill of exchange. On the due date, neither you are visible nor your instrument is visible. Now, what will I do? Do you really think I will keep waiting for you? Mere Karan Arjun aayenge. I will recover the money someday. No nonsense. Section 117 says, in a scenario of this sort, all right, the holder can recover 3 types of expenses. First is towards the presenting, noting, and protesting. If I have incurred any expenditure, I will recover it from you. Second, all right, if I have any foreign exchange, all right, because you are staying in some other country, I am staying in some other country, and because of that, there is a change in the rate of exchange, then that change in rate of exchange also I will claim from you. The third one, very important, I will get an interest of 18% per annum. These are 3 important pointers which you will have to remember. All right. The rest is again repetition of protest charges, rate of exchange, and all of those. This is about your section 117 rules of compensation. Now, if you guys see this material which has been circulated with you, consciously I had put 2 RTPs and 1 mock paper as well, or rather the previous year paper as well, so that you guys have a fair idea of how it looks like. All right. Now, pay attention on negotiable instruments. Don't take it for granted. 10 to 15 marks, easy questions are going to be there in examination. Pay attention on that chapter. All right. With this, we have finished 4 chapters. All right. I hope I've done justice to your time. We've spent 1 hour, 15 minutes odd together. Now, how do you approach the paper, guys? Please, are you guys reading right now, or when are you guys going to read this chapter, this subject, or over revision?
Sir, we have mock test.
When do you have the mock test?
Friday.
Friday. So today is Wednesday, correct? You will be reading till Friday. That is the whole plan. That is the whole thing for law, right?
Yes, sir.
All right. So let's assume today 100% nobody is going to open your books. Even if I ask you, you won't. Relax. I know you. All right. Tomorrow, just approach as if you're going to approach your on those 1.5 or 2 days before examination. How will you approach your examination? Approach accordingly. First thing. Second thing, guys, very, very important. Today, when you're reading, or tomorrow, when you're reading, you have to be very clear of which material you will refer 1 day before examination. It cannot be 1,000 materials, it cannot be 1,000 books. It has to be only one single material, nothing else. My suggestion is you can refer to CAPS material, because CAPS material pretty much we have covered comprehensively. All right. However, for case studies, immediately after each chapter gets over, go refer to the case studies as well from the study material and close it. 99% case studies are also covered as a part of your CAPS material itself. But just in case if there is any additional question, any additional example which is there, finish it then and there. Today, same approach on the date of examination as well. Today, when you're reading, let's assume there are everything is covered in CAPS material. Assume there are 2 or 3 questions which are there extra in your study material. Write it down in the CAPS material today itself. Tomorrow and day after, when you're preparing, write it down then and there, so that on the date of examination, no book other than my CAPS material. Nothing more than my CAPS material. As simple as that. Are you guys understanding? Everyone? Yes?
Yes.
Solve RTPs as in when you're finishing the chapter. Do you remember when I had taken the revision just the last week, how I had approached, finished one chapter, immediately went and solved the RTP. Finished one chapter, immediately went and solved the RTP. This is exactly what you guys are going to do. Don't solve all the RTPs after the entire syllabus is over. Reason being, you will be in a huge panic if you're not able to recall anything. You will again flip through the entire books thinking that you don't remember whatever you've read. Am I making sense to everyone? All right. Finish the RTP as and when you finish the chapters. On the date of examination, you're going to refer to only one material, one book, whatever you're comfortable with. I'll leave it to you. According to me, CAPS material is pretty good. All right. That should be decent. Revision material also. Now, just worst case, sir, I'm not able to finish the syllabus on the date of examination. Nothing is happening at all. Use this revision material. All right. Revision material also comprehensively, we have covered quite a lot of details itself. So you don't have to worry around the material which I had sent was of 80, 82 pages, because almost 60 pages were your RTPs and mock papers itself. So ensure that you go through. Decent amount of coverage is already done. I'll not be taking any questions, sir, because your question might end up freaking out everyone, unless you have something on the approach. If you have some question on the approach, you can ask.
No, sir. No, sir. It was relating to top.
Mir, I told you, you can drop an email. I will reply to you. All right. You have my email IDs, right? Everyone?
No, sir.
All right. I will drop it right now. Don't worry about it. Okay. So let me know if you can see the screen. You can drop your email query here. I will revert to you by tomorrow itself.
Yes.
All right. Does not mean that moment you send within split seconds, if you reply, expect my reply. I don't reply to the places where I work. And there's a separate concept altogether. All right. I will take my sweet time, but I will definitely reply. Don't worry. Very important, guys. Next 10 days, control your nerves. All right. My suggestion, please drink as much as water possible. Do a little bit of exercise. It'll help you. It'll give you a break. Don't behave as if the world is going to end within these 10 days and you're going to live only within the books. Even it's unsaid, you won't do it. All right. I know you. But just in case if there is anybody here sitting with the books as if there's no tomorrow at all, today itself I have to cover everything, please don't do anything of that sort. Unnecessary, you will create pressure for yourself. All right. Worst case scenario I'm talking about. Worst case scenario in examination, on the date of examination, just in case if you're not able to complete the entire syllabus. Trust your instinct, trust your efforts, which you have put till now. All right. You will be able to remember. Stop telling yourself every now and then, I don't remember what I have just read, I don't remember what I've just read. That is, indirectly, you are telling your subconscious mind that they need revision. And you cannot give so many revisions in the next 10 days. The moment you feel you're not able to recall something, relax. Take deep breath and calm yourself. Whenever you feel you're losing your control, no, do a little bit of left nostril breathing. All right. Now, what is this left nostril breathing is? Block your right nose. All right. And 3 from your left nose. Simple as that. All right. This is linked to your parasympathetic nervous system. Just in case if you want the science, because we don't believe in anything, we don't believe in magic. We need logic, is what most of us are sitting here with. All right. So just in case if you need the logic, it is linked to your parasympathetic nervous system, which calms down your body. Your right nostril is linked to your sympathetic nervous system, which gives you more of those hormones which are required for fight or flight. You don't need to do anything of it. You just need something which calms your body. So left nostril breathing. Keep doing it once in every hour, once in every 2 hours. Whenever you think you're losing patience, you're not able to control yourself, you're scared about every small thing. That stupid friend of yours might have called you 1 hour before examination, asking for a stupid doubt which you don't even know and freaking you out. First of all, don't entertain. Second, even if there is anything of this sort, keep telling yourself this question will not come in examination. I'm telling you, this will not come in examination. All right. I have had instances where I remember I wasn't ever, so conscious. Some stupid friend might call out the blue. I've never spoken to him, but on the date of examination, he remembers there's somebody called Mehul. He might know it and he reaches out. And that guy has ruined my 4 hours of examination at a stretch, because after writing the exam also, I might be thinking about the question which he is asked me, though it might not be there in the examination. Third, all right, if some stupid, first of all, don't entertain questions. All right, somebody asks questions, you should have asked long back, not now. Even if there are any questions, and if you don't know the answer, keep telling yourself this will not come in examination. Relax. All right, this will definitely, everything cannot be, entire study material cannot be asked. Your examination is only for 100 marks, first of all. They can't ask a 500 marker question paper for 100 markers. I hope I'm making sense to each one of you. All right. One last thing. All right. Stay confident, because that solves majority of a problem. You don't have to study for 12 hours, 14 hours, 16 hours. No. If you're studying for 8 hours, give the best 8 hours that you can. All right. In the next couple of days. If you're studying for 10 hours, you can give the best 10 hours that you can give for the next couple of days. Just give the best. Don't get distracted. Don't talk about various unnecessary things. If you're getting carried away, just keep taking breaks as and when required. All right. I personally believe in a concept of 55-5. I study for 55 minutes. I take a break of 5 minutes. This is something that I do even today. All right. Even today, when I have to go think about all of those examinations, and I write exams. All right. So even I come across all of these situations, and it's pretty common. Relax. Study for 55 minutes, take a break of 5 minutes. Now, that 5 minutes shouldn't be Instagram, Facebook, and all of that. Huh? Because how this 5 minutes will end up becoming 55 minutes, you will not realize. This is stupidity. One step closer to another attempt. Come back again. All right. Don't do this problem. Don't do this mistake. You go talk to your parents, drink water, go for a walk, do whatever it is. Don't get distracted. As simple as that. You want to listen to more music, go do so. All right. Accounts paper is going to be your first paper. 99.99% of you will come back home tired, exhausted, mentally, physically, for whatever good or bad reason it is. All right. Don't let it affect your next paper. If the paper was good, what else can you ask for? If the paper was bad, do you want to ruin the next 3 papers or not? Ask yourself. All right. And I still remember, I can't resist. Guys, I'm so sorry. First of all, I'm going overboard with time, but I hope that's okay with each one of you. I remember CA final examination, I was writing a paper called as SFM, all right, strategic financial management. It was not strategic financial. It was financial management, all right. So 100 marker paper, and I had prepared extremely well, all right. I had prepared in a manner that, there will be nothing in the question paper which I'll not be able to answer. Now look at it. The confidence was over the roof. It was going beyond the roof. That was the whole confidence. And trust me, I put in efforts as well accordingly. And 1 or 2 days before the examination, I didn't sleep. My sleep hours was hardly 3.5, 4 hours. That's it. That was for a span of 48 hours. In a span of 48 hours, I just slept for 4 hours. I remember that. I go to the examination hall. The first 15 minutes, I get the question paper. I was confident of getting 80. I was confident not of writing 80, of getting 80. Because pretty much everything here was something that I had come across. I had solved it. First 1.5 hours, best 1.5 hours that I could spend. After first 1.5 hours, the only thing which my body and brain was saying, I don't want to write any further. I'm not talking about anybody else. I'm talking about the same person who's sitting right in front of you. All right. Luckily, I was able to finish, somehow pushed writing for 65 marks. I remember 65 was the maximum. I was planning. I was so confident that I get more than 80. I could write only for 65 marks. God's grace, I cleared the paper. All right. With a decent mark out of 65, I ended up scoring 52. I remember the score because I was clear that I'll not clear the paper. I was very confident that I might not clear the paper. But this is the blunder which each one of us will end up doing in examination. What? First, not sleeping for sufficient time during examination. Guys, the brain generates a lot of heat. You just touch your head and you'll realize, if you're studying for continuous, just touch your head, you will realize the heat which is generated. The only way to calm down is going ahead and sleeping. And that if you compromise, you will compromise on your health. And this is exactly what I did in my examination. You don't have to, it's good to learn from your mistake, but it's not that you can commit all the mistakes in the world. You don't have so much time. I hope I'm clear, everyone. Understanding? Yes. Now, first 15 minutes which you get in the examination, all right, use it so judicially that though you will have to use it very judiciously because this is going to make it or break it. All right. When you're writing any answers in the examination, the first 15 minutes have to be very, very crucial. And how will your last line reading for understanding the questions? If you remember, how do we approach the question? Reading the last line so that you get a flavor of the topic. All right. That art is going to help you during the 15 minutes because you will not be able to read the entire question paper in 15 minutes. Am I making sense to everyone? Yes. So there is a high possibility that you might not be able to make entire 15 minutes and reading the entire question paper may not be possible. So first 15 minutes when you're reading the question paper, you have to ensure that you are very certain of which optional question you're going to write. After that, there cannot be a change. I'll tell you what happens is you have decided, say question 4, I'm going to write. And I didn't read one of the sub questions of 8 marks itself, which was there in the question paper, which I didn't read. Now, what has happened? You've started question 4, you've written 4A. In 4B, you are not sure of what to write. Back to square one. You've chosen a wrong question. Now, the problem is you can't scratch this entire answer and write another question because you've already spent 10 minutes on writing 4A. You've lost time. First 15 minutes, more than being calm during those 3 hours, I want you to be calm during the first 15 minutes. Because during those first 15 minutes, you will understand and finalize on what you want to write. Am I making sense to everyone? Yes. In law, even if the questions are lengthy, the art that you guys have already learned of reading the last sentence and making some question out of it, at least getting your heads right, that will help you in at least deciding the question. When you're writing the examination, guys, please make it a note. The first question which you write has to be the best question. You don't have to follow the sequence which is there in the question paper. Just because question 1, 2, 3 is there, is it necessary that I have to follow the same 1, 2, 3? Nah. Let's assume, sir, the question number 3 is something that I'm very confident. In the first 1.5 hour or first 1 hour, you write all those questions which you're confident about. After 1 hour, after the first hour gets over, go complete your compulsory question. Come back, write the balance questions. Am I making sense, everyone? Yes. One very important thing, a 4 marker, you have to write an answer as if it is a 4 marker. Don't write as if it is a 40 marker, expecting 40 out of a 4 marker question. This is the mistake which we do. If you know some topic, you just end up writing so much that you forget that this is not going to fetch so much marks to me. The answer for a 2 marker and a 4 marker cannot be the same. The answer for a 4 marker and a 7 marker cannot be the same. Am I making sense, everyone? For a 4 marker, write 6 points. For a 2 marker, write 3 points, depending on what the question is. If the question is straight to the question or to the point, then you can't write in points. You will have to think about it, what has to be presented. Very important. Let me know if you can see the screen. This is something that I've discussed during the examinations as well. I mean, during your early revisions as well, but nevertheless, I'm going to talk about it quickly now. When it comes to your examination, guys, let's assume this is your answer script. All right. Let's assume I know question 3A. Write the best of it, whatever you want to. Will I write question 3B also here?
No.
Yes.
No, sir.
Answer is don't save projects. Don't save papers during examination. CAPS has multiple projects. You be a part of it. Don't save paper in the examination. Even if you end up wasting a lot of page and space here, it's okay. Please don't continue question 3B here. Write down question 3B again in the next question. Next page. So where to write a question number? Left corner, right corner, bottom of the city, right of the heart. Where?
Middle of the page.
Right in the middle top of the page. There's no confusion at all. You will not, guys, very simple. The evaluator, whoever is correcting your paper, is a human being. It's not an automated AI who's going to correct your paper. It's not a robot who's going to read your answers. Am I making sense, everyone? Don't make his life messy. Don't make his life messy. Am I making sense, everyone? Yes. So ensure
sir.
that you please write every question in the same sequence. Question 3A, 3B, 3C. All right. Now let's assume. So 3A, I know. 3B, I will come back later and write. Should I leave page here only, or can I write later on somewhere after question 5A, 5B and all? Now, leave page. It's okay. Come back later. Don't play around with the evaluator, asking him to play, do a treasure hunt in your answer script. Don't do all of those. You will end up, annoying the evaluator. And if somebody is like me, luckily there should not be, all right. I will not hesitate in giving you marks lesser than what you deserve. Don't do the blunder. I hope I'm clear, everyone. Understanding? So you're going to write the answers in sequence. If you're taking question 3 first, question 3A, 3B, 3C. No problem. It need not be one itself. It can be 3A, 3B, 3C. Then I want to write 5. 5A, 5B, 5C. Should I leave space between 3 and 5? 6, 7 pages will I leave and come write question 4 later? Don't do that. You take an entire sub-question. You take an entire question, write it in sequence, go to the next question. That need not be in sequence. I repeat, what am I trying to say? 3A, 3B, 3C, I know. 4A, 4B, 4C, I want to write. So should I leave pages now? Or can I write it later on after 5? 100% you can write after 5A, 5B, 5C. Acceptable. Not an issue at all. Understanding? Handwriting. Don't be doctors. All right. Nowadays, even doctors are writing fairly well because people have started complaining to tell them that we don't understand what prescriptions you are giving. You're giving a paracetamol, or are you giving some other drug which we don't understand? You, being chartered accountants, don't test the patience of the evaluator. I repeat, don't play treasure hunt with him in your answer script. He will never find any treasures then. What am I trying to say? Handwriting has to be legible. I'm not asking you to write calligraphy in your examination. At least ensure that I can read what you've written. Please make a note. Whenever you're writing answers, let it be in bulletin points. You're not going to write paragraphs. No paragraphs at all. Every bulletin point will have one word which is underlined. Why underlined? Because I want the evaluator's attention only on that important word. Example, when I'm talking about small LLP, very simple. Contribution, 25 lakhs. Turnover, 40 lakhs. I will write these points. I will write the entire sentence. All right, the contribution of the partners should not exceed 25 lakhs. I will write the entire sentence and I will underline these 4 words. Contribution, 25 lakhs. turnover 40 lakhs. So that, guys, it becomes very clear for the evaluator, and you're drawing his attention only to what needs to be read. You don't want him to read everything. Am I making sense to everyone? Yes. Write in points. If it is a case study, you're going to write the case study in a particular format. How? Facts of the case, provision of law, analysis, conclusion. Conclusion, sir, can I write paragraphs together? No, it's a conclusion, write one sentence. Whatever paragraph you want to write, whatever history you want to write, you write in analysis. Understanding, everyone? Yes. Facts of the case, provision of law, conclusion, and provision of law, analysis, conclusion.
Sir,
Everything
line
needs
ಬಿಡ್ಬೇಕಾ
to be-
sir?
I'm sorry?
Sir, 1-2 line ಬಿಡ್ಬೇಕಾ sir?
No need to leave lines and all, because if the evaluator thinks you're done with your answer with the facts of the case, he might think this is a separate answer altogether. Don't do that. All right. What are you going to do? Assume this is the question. Facts of the case, provision of law, analysis, and conclusion. Just keep underlining and start writing under this. As simple as that. Understanding? Yes. So question 3B, facts of the case, provision, analysis, conclusion. Simple method for writing answers. I think I have pretty much covered what I intended to. I'm going to see you again, probably 15-20 minutes, one day before your examination. I will not take any academic questions right now. All right. Tanushree, if you have anything else, please go ahead.
Sir, my question is, if they are given as 3A and given subquestions as 1 and 2, should we write in paragraph for this, or should we write in a little like conclusions?
Depends on what kind of question it is. If it is a question which is case study, then you will have to write 3A, 1, write your facts of the case, provision. Second question, all right, 3A, 2. You're going to write your second sub question. If everything can be fit in the same page, write it in the same page. That's absolutely fine. Understood? Because it is all pertaining to 3A. So I'm okay with it. Next, Ananya.
Sir, if we are not sure about the section numbers, then what we have to write in the place of troubleshooting?
Simple. Should you be sure of the section number? Answer is yes. How do you do so? Now, when you're preparing, just ensure you make a last pager. As and when you come across section numbers, keep writing in the last page. All right, one day before examination, just read those and go home. Not able to remember at all. Section number, name of the act. This is how you're always going to write your answers. Section 2, clause TA of LLP Act 2008 defines your small LLP. Sir, I don't remember the section number itself. Write the name of the act. Sir, I don't remember the name of the act also. Hopeless. All right. In that scenario, you write as per the provision of law. Simple. Understood?
Yes,
and guys, just in case, sir, there are too many section numbers, I'm not able to remember anything at all. It's okay. All right. If you remember, you will earn brownie points. If you don't, you might end up losing out that brownie point. As simple as that. Section numbers will just create an impression on the evaluator that you put in extra efforts in remembering things. Understood? Yes. Good. Srinikitan.
Sir, can facts should be mentioned as a point, sir?
Facts has to be only 2 sentences. Once you're writing facts, provision, analysis, conclusion, those can be in paragraphs. I have no problem. All right. Because you've already broken the answer itself into pointers. Facts is just going to be 2 sentences. You're not going to write the entire question again. I repeat, facts of the case have to be only 2 sentences. What you've understood, what is the problem in the question? That's it. Provision, analysis, you can write in paragraphs. You can write in pointers. I would suggest always reading a point is simpler than reading a paragraph. Who wants to sit and read paragraphs? If I ask you to sit and read paragraph, would you be okay with it? Answer is no. The other person is as good as you are. All right. Anything else? That's it. All right, guys. So we've spent 1.5 hours. I suppose more than that itself. Hope we've done justice to each other's time. Next 2 days, stay calm. You'll be able to complete this paper. It's an easy paper. All right. Law is, I love teaching law because I know that I can create images in the mind. I can create stories on a particular topic. I can somehow recollect and bring it in the answer spread. All right. That's exactly what you guys have to do. It's an easy topic, easy chapter. You can sail through with an easy manner. Just that you will have to pay attention when you're reading. Don't get distracted. Stay calm and go for your examination. With this, I come to an end of my session. Thank you so much. Have a nice day, guys.
Thank you,
Yes,
sir.
Thank you,
sir.
sir.